the SDAB. My name is Ian Walkowicz, and I'm here representing the Boyle Street Services Society. That is the society, not a corporation, a nonprofit society that operates a number of socially directed operations throughout the city of Edmonton. And it is a society that's applied for and received a development permit from the city of Edmonton to operate the Strathcona Health Hub. How I mean to proceed today is I will make some initial statements and comments about various legal issues and the framework of the bylaw, the nature of this development, and why I believe the appeal should be dismissed. After that, you'll hear from various people from Boyle Street who will be able to speak to different aspects of this development. We're going to hear from a Miss, sorry, make sure I get the pronunciation right. We're going to hear from Ms. Adaricio from Boyle Street Services Society, who will be able to go through this development and show you all exactly what this development is. One of your jobs today is, what is this development? What is the use being applied for? And Ms. Adaricio will be able to walk you in great detail to show you what it is that's going to be occurring at this development should the appeal be denied. And I think when you finish hearing her presentation, you'll understand that this is about healthcare. This is about providing health services to certain members of the public. We'll also hear from, all the way from London, so he's online, Mr. Croy Johnston, who is in the architectural firm, who will be able to talk about a couple sort of more issues dealing more with the building itself. And then very briefly, we'll hear from a Mr. Elliot Tanti, who is also with Boyle Street, and who was at the last meeting that was held by City Council, the public hearings, when the direct bylaw, the direct control bylaw that we're dealing with today was passed. And he can speak to what was at issue then. He will also be here to answer any questions about consultation. I don't know if that's an issue for the board or not. We won't make any specific submissions on it, but if there are any questions the board has, Mr. Tanti will be able to answer any questions should they arise. Finally, then I will summarize our position again. So, let's begin. This is an application for a development permit in a direct control zone. So, the starting place is the direct control bylaw. And we have a relatively new bylaw passed January 23rd, of 2023. It is bylaw 19988, and it's in your materials at a number of locations, but we might as well refer to the same pages that were used during the appellant submissions, and that is at page 57 of the of Ms. Agrias' submissions. So when we look at the DC bylaw, we note that it lists 51 uses. Now, these are listed uses. Now, in a direct control bylaw, we don't have permitted uses versus discretionary uses that you have in regular zones. You simply have lists of uses which are allowed. So all these are basically permitted uses. If you have one of these uses, you are allowed to have a development permit. And one of the listed uses is health services. And I'm going to show you, when we go through this, that what has been applied for is on all four corners with health services. It is health services. It can't be anything else other than health services. It is noted, and has been noted by the appellants, that another use class called extended medical treatment services is not one of the listed uses. So I will go through to show why this is not an extended medical treatment service. So if it is a health service, then the use is settled. And the use can't be looked at again, and it's not a discretionary use where you have a duty to balance the proposed use with other competing land uses. This is what you do when it's a discretionary use. You say, okay, this is a discretionary use, meaning City Council, when they passed the bylaw making a use discretionary, said, it may fit in with this neighborhood, it may not in this zone, so we'll have to look at it on a case-by-case basis and assess whether there are competing land uses. With permitted uses in a regular zone or listed uses in a direct control zone, City Council has deemed them to be compatible. That's why they're listed. City Council said, no, in this area, these uses are compatible uses. And so let's look to see whether or not this is a health service. As the people from Boyle Street, when they come, they'll give you more details about the use. But in a nutshell, there are several health services being offered. The one health service that is causing a lot of issues and that submissions have been made that it's not a health service is the safe injection site type of uses. This is where there is, in a controlled manner, a supervised consumption of drugs that, if they were consumed elsewhere, would be illegal. How can we have such a use? One of the appellants mentioned that, well, this is illegal, this is criminal. Well, it's not. It's not, because what makes it illegal is a federal statute, the Controlled Drugs and Substances Act. And I just lost it here. There we go. And that act is an act of the federal parliament, and it's the act which creates what you might say are illegal drugs. When people say, oh, there are illegal drugs, well, how did they come to be? Well, they came to be because of that act. Without that act, they're not illegal. That same act, however, doesn't say they're illegal all the time. That act allows for exemptions for medical purposes. And those exemptions are found in section 56.1 of the Federal Act. And I'll just read the section to you. It says, sub 1, for the purpose of allowing certain activities to take place at a supervised consumption site, the minister may, on any terms and conditions that the minister considers necessary, exempt the following from the application of all or any of the provisions of this act or the regulations, if, in the opinion of the minister, the exemption is necessary for a medical purpose. And then what's exempted are, A, any person or class of persons in relation to a controlled substance or precursor that is obtained in a manner not authorized under this act, or B, any controlled substance or precursor or any class or of either of them that is obtained in a manner not authorized under the act. So the federal government has created an exemption for medical purposes, and that's important. It's medical purposes. I can't just do this immediately. I have to ask the federal minister, the federal government, to grant a certificate for it. I have to apply. Subsection 2 of 56.1 describes the application and the whole application process. An application for an exemption under subsection 1 shall include information submitted in the form and manner determined by the minister regarding the intended public health benefits of the site, and information, if any, related to A, the impact of the site on crime rates, B, the local conditions indicating a need for the site, C, the administrative structure in place to support the site, D, the resources available to support the maintenance of the site, and E, expressions of community support or opposition. And the minister takes all that into account, the federal government, and they make a decision, which includes community support or opposition. They take that into account. Sub 3, an application for an exemption under subsection 1 that would allow certain activities to continue to take place at a supervised consumption site shall include any update to the information provided to the minister since the previous exemption was granted, including any information related to the public health impacts of the activities at the site. What that means is these things are time sensitive and you have to apply for extensions. And when you apply for the extensions, the federal government looks at what happened. How was it? So this is a whole entire federal regime done by the federal government as part of the Controlled Substances Act. So it's not, as some people have implied, some sort of illegal activity. This is part of the Drug Control Act, which includes both prohibitions on certain narcotics and other illicit substances, but also controls certain ways that we can assist people who are having problems with those substances. And Section 56.1 is one of those sections. It is part and parcel of our federal government's approach to certain controlled substances. This place can't operate unless the federal government gives it its license, and they will have to obtain that. If they don't, it won't operate because the federal government has to do it. They won't grant the license until they know that everything is in order, but they will have to grant that license or this will not occur. So as you can see, all of the aspects that the federal government looks at are health related. What are the public health impacts? Let's look at the other words in the Act. Necessary for a medical purpose. They have to convince that this is necessary for a medical purpose. A lot of the submissions yesterday revolved around this concept that at this facility there are going to be traditional healthcare services. And then there's going to be safe injection. And they're somehow different things. They are not. The safe injection part of this development is part of the health services. It is a health service. During the submissions yesterday, a lot of comments were made about, well, this health service wasn't part of the definition of health services at the time that the bylaw was passed. It wasn't contemplated. Well, is it a health service under the bylaw? Let's look at what the bylaw says. Health services are defined in the bylaw as follows. Health services means development used for the provision of physical and mental health services on an outpatient basis. Services may be of a preventative, diagnostic, treatment, therapeutic, rehabilitative, or counseling nature. Then they list the typical uses. Typical uses include medical and dental offices, health clinics, counseling services, and medical cannabis clinics and counseling services. So it's incredibly broad. It doesn't need to be expanded to include anything which the medical profession considers to be diagnostically, rehabilitatively, or therapeutically valid. There are many types of health treatment modalities that some people agree with and some people disagree with. They're not all universally acclaimed. Some people have issues with chiropractic treatment. Some people have issues with acupuncture. Some people have issues with various types of therapy that they may not like. That doesn't mean they're not health services. There may be health services that you think maybe aren't as effective as others. Maybe you don't think chiropractic is worth anything at all. It doesn't mean it's not a health service as defined by the bylaw. And having a supervised consumption site registered by authorized by the federal government is simply one more type of health modality, of treatment modality that is now being advanced by the medical profession. It is therapeutic, it's a form of treatment, it's rehabilitative, it has all these aspects to it. It is medical treatment. Now, you don't have to take my word for it, because I'm not a doctor. What do I know? But let's talk about some people who do. If you look at some of the materials that we submitted to the SDAB, I think it's listed under the name letters of support. Those letters of support are more than just letters of support. Some of them are your traditional level support. I work in the field. I like this development. Some of those letters, though, are not just letters of support. They're letters to show that the medical profession considers supervised consumption sites to be a form of treatment. This is treatment. This is treatment or diagnostic, therapeutic, or rehabilitative. Let's look at the first one. The first one we have in our materials submitted is a letter written by Catherine Dong, MD, and so many letters afterwards, I won't read them all out. She is the Alberta Health Services Chair in Emergency Medicine Research, an Associate Professor of the Department of Emergency Medicine. She's also an addictions medicine physician at the Royal Alexandra Hospital, and wrote a letter on June 16th, which is in our submissions. And I'll just read the first couple paragraphs. An overdose prevention site, OPS, located in the proposed Strathcona Health Hub, would provide access to an urgently needed health service. Deaths due to drug poisoning remain elevated among pandemic levels and are entirely preventable with access to immediate medical care, such as that would be provided within an OPS. Access to supervised consumption services is considered part of the medical standard of care for people with opioid use disorders. And she has footnotes from two different papers, which I won't go through it. You can read the whole rest of her letter. I won't read all of it, but that's the key point. I think that an addiction medicine physician is in a better place than others to say, no, this is part of healthcare services. As she said, it is medically standard care for people with opioid use disorders. Let's look at the next one. The next one is a letter dated June 16th, 2023. And it was signed by 4 people. One, Dr. Christopher Sikora, the lead medical officer of health for the Edmonton zone for Alberta Health Services. We have Mark Snatters, the executive director of addictions and mental health for the Edmonton zone. We have Dr. Daniel Lee, Edmonton zone clinical department head for addictions and mental health. We have Stephen Cleland, the executive director for addiction medicine and virtual opioid dependency program. And they say the same thing. To whom it may concern, supervised consumption services, including overdose prevention sites, are part of a range of evidence-based services that aim to reduce harm, support prevention, and provide treatment for Albertans. It goes on and on. I won't read it all, but again, I think those are people who know what medical treatment is, and they indicate that this is medical treatment. We have a similar one, which I won't go through, from Dr. Monty Gosh, who is a doctor of internal medicine and disaster medicine and addiction medicine, and is assistant professor at the University of Alberta. We have another one signed by Dr. Amit Singh, a clinical professor, which also mentions the same thing. Also dated June 13th, where Dr. Singh writes, the addition of an overdose prevention site to the Strathcona Health Hub ensures that much-needed health services will be offered to the vulnerable clients who access this facility. The goal of an OPS is to provide a wide range of health support for people who use criminalized substances, including overdose prevention and response, preventative, diagnostic, treatment, therapeutic, rehabilitative, or counseling services. These facilities save lives and improve health. In the past, these sites have demonstrated the ability to provide a wide range of health services. There's the next one, by Dr. Ryan Cooper, the Associate Professor in the Faculty of Medicine. Says the same thing. Dr. Sandy Dong, the next one, an emergency physician for the Edmonton zone and a clinical professor at the Department of Emergency Medicine, says the same thing. A letter from June 19th, 2023, which lists several physicians, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 of them. So one of the appellants said yesterday, no reasonable person would consider supervised consumption sites to be health services. Well, all these experts do, including the people from Alberta Health Services, the lead medical officer of health for the Edmonton zone, and addiction medical physicians. It is health services. So let's look at the definition again after reading that. It means development used for the provision of physical and mental health services on an outpatient basis. Services may be of a preventative, diagnostic, treatment, therapeutic, rehabilitative, or counseling nature. That's what this is. Not just the other parts, but the overdose prevention site parts as well. It is medical treatment. I want to briefly take a look at the extended medical treatment services definition because there has been an argument put forward that it doesn't fall exactly within health services. I don't accept that. I submit to you that it is absolutely within health services definition. But let's look at the difference with extended medical treatment services, and I'll propose that it's not at all an extended medical treatment service. Extended medical treatment services are defined to say means development providing room, board, and surgical and other medical treatment for the sick, injured, or infirm, including outpatient services and accessory staff residences. Typical uses include hospitals, sanitariums, convalescent homes, isolation facilities, psychiatric hospitals, auxiliary hospitals, and detoxification centers. Basically, these are hospitals, auxiliary hospitals. They talk about providing room and board. There is a mention of outpatient services, but that just allows a hospital to then also provide an outpatient service. You can go to the U of A hospital and they will have an outpatient clinic. Without this, they may not be able to have that. However, the definition means development providing room, board, and surgical and other medical treatment. Room and board. It's about overnight stays. That's what the hospitals are. It also included a detoxification center. So if you're going to go somewhere, you're going to stay for 6 months or 6 weeks, obviously that would be extended medical treatment services. It's right in the word, extended. Health services are for clinics where you go in, you receive treatment, and you leave. Extended medical treatment facilities are where you go in and you stay. Outpatient services are allowed for extended medical, but it's ancillary. No one's staying overnight here. So it can't be an extended medical treatment service. It just doesn't fit. It does fit health services, and it is a health service. It is a listed use. So, with that, we have to talk about, so the deeming provision, I submit, doesn't have anything to play at all. The deeming provision is when, we should just look at it very briefly here. It's a from the bylaw 7.1.b, where specific purposes or activities do not conform to any use definition or generally conform to the wording of 2 or more use definitions. That's the triggering for the deeming provision. That's not our case here, because we have one that fits exactly with health services, and it doesn't fit at all with extended, because there's no overnight stay. There's no extended part of extended medical treatment services. So it simply doesn't apply. So we have a listed use. I think it's very clear that everything that's happening here, the treatment, the supervised consumption site, and the other health treatment are all health treatment. And as I said, we're going to have Ms. Adaricio come from Boyle Street just to go through a typical day. What will happen there, and you'll see for yourself that that's what it's all about. This leaves us with one issue, because now we have in a DC appeal, as you're all familiar with, your only job is to determine whether or not the development officer followed the directions of council. Did they follow the directions of council with respect to the use? Yes, they did. Did they follow the directions of council with respect to all the development regulations? Here's where we have the issue, and we have the issue of the ramp. Not really the ramp, I should say, the step. The ramp is a potential remedy to the solution, but we have a step. If we look at the photographs that were kindly provided by Ms. Agrius, and if you look at page 43 of the appellant's materials, you can see that in front of the building, it's the building that has the word marbles on it, there is a problem, is that there is a step. There's a small step there. That is a problem because the DC bylaw incorporates by reference the Main Street overlay, which is section 819 of the zoning bylaw. And if you go to that overlay in 819.4, there's a regulation that says where a commercial use, and health services are a commercial use, so it does apply, where a commercial use is provided at ground level abutting a public roadway other than a lane, the principal entrance shall be designed for universal accessibility. So note that universal accessibility isn't a defined term in the bylaw. It is really a reference to a building code issue. Now, it's in the bylaw, so it is a development regulation that you have to design it for universal accessibility. Without it being defined, it's a bit difficult to say for sure exactly what is intended by universal accessibility. But I will concede that what most people would think it to mean is what those building code people do. And indeed, Ms. Agris has put in her materials referenced from the building code type of document which describes how under the building code universal accessibility is obtained. So with that small step there, we do have an issue is that that's probably not part of universal accessibility because you couldn't roll a wheelchair over it. And that's what we're talking about, sort of wheelchair access wouldn't be there. Now, if you look at that same picture, you can see that same step is in front of some of the other buildings as well. It looks like it's in front of Alhambra Books, a similar step. So it's been there for a long time, and until now, it would have been a non-conforming building. Now there's a development permit, so now we have to deal with it. So, following up in the argument I made, and yesterday morning, and similar to the position of the city, I believe there are two ways that this board can deal with this issue. One, the board can deal with this issue by a condition that simply requires compliance. I think that condition can be done, quite frankly, even though we submitted a potential plan for how that compliance can be done, i.e. a ramp. There are a lot of things with that ramp. Obviously, it's on city land, which means we have to apply for an encroachment agreement. And the city has already been approached about a potential encroachment agreement. That would have to be dealt with. So the board could deal with it by simply conditioning compliance. Because universal accessibility isn't a defined term in the bylaw, it really is simply a reference to a building code situation. It's not a case where a condition would have to have extensive plans or anything of the sort, because it's not complying with, let's say, a whole overlay or complying with very specific dimensions in the zoning bylaw. We just have an undefined term, universal accessibility. As Mr. Gunter pointed out, the building code officers may want that in any event. So the board could simply condition it. I also submit that the board could also grant a variance and waive it. And there may be reasons why the board may prefer to do that. And here are the reasons for that. First, and just to quickly summarize my submissions yesterday, can the board issue a variance when you have a direct control appeal? After all, you're simply there to determine whether or not the development officer followed the directions of City Council. Well, here it appears that there was one thing missed. And the thing that was missed, and we heard about it yesterday because of a confusion as to where the entrance is going to be, it got missed that this universal accessibility thing. So one could say that there was an error of the development officer in failing to address in some manner section 13 of 819.4 of the zoning bylaw. That means you can now substitute your decision, but only to ensure that section 819.4 is satisfied. You can do this by granting a variance to that provision, as the Garneau, the Court of Appeal confirmed in the Garneau decision. I think all council are in agreement that you cannot use your normal Section 687 variance power to vary this. When you are following the directions of council, a direction that the development officer did not make, you can exercise whatever variance power that development officer would have had. Because remember, their variance power is also part of the directions of council. Council directs them, as the Garneau decision said, that you do have to look into whether or not a variance could be granted. And this direct control bylaw explicitly contemplates variances from the Main Street overlay. I dealt with this yesterday, but might as well just read it again. The Main Street overlay is incorporated by reference in Section 4.1, and Section 4.1A says the development officer may exercise normal variance power for those regulations of the CB2 General Business Zone and Main Streets overlay, so that's what we're dealing with, in accordance with Section 11 of the zoning bylaw. Section 11 is the section that includes the general variance power of the development officer. And there are two sections of importance, Section 11.3 and 11.4. 11.3 allows the development officer to vary, and the test that's cited there is identical to your Section 687 test, so it's a test you deal with every day. And it says, it actually has both sub 1 and sub 2, both may have implications here. 11.3.1, the development officer may approve with or without conditions, and as a Class B discretionary development, an application for a development that does not comply with this bylaw where A, and then they just cite the normal variance test that is a word-for-word copy of Section 687. And then sub 2 is the development officer may approve with or without conditions as a Class B discretionary permit an enlargement, alteration, or addition to a non-conforming building if the non-conforming building complies with the uses prescribed for the land in this bylaw, and the proposed development would not, in their opinion, and then again cites the 687 variance test. And that either of those things would apply here, because remember, this building is old, the building beside it is old, they have this little step. And that step doesn't comply with the Main Street overlay because you can't put a wheelchair over this little step. So it could be done in either one of those ways. So the development officer had two ways to do it. Either just say, I'm going to allow an alteration to a non-conforming building, or sub 1, just a normal variance. Now, unlike your normal Section 687 variance, which just ends there, the development officer's variance is then more restricted. And those restrictions come in the next section, 11.4, limitations of variance. So this is where in Section 11.3, they give them what looks like your exact variance power. Then the next one, they take it back. And they take it 4 things back. In approving a development permit pursuant to 11.3, that's the DO's variance power, the DO shall adhere to the following. A variance may be considered in cases of unnecessary hardship or practical difficulties peculiar to the use, character, or situation of the land or a building, which are not generally common to other land in the same zone. So the first thing is they have to have some sort of a hardship or a practical difficulty. Well, I would say that this is made exactly here. If there was lots of room between that we could put between our front entranceway and the sidewalk, we could have a ramp easily. We wouldn't need any variance, or we wouldn't need to be looking at waiving it. It would be easy, but we can't, because the door and the step, if you look at the plans, are right on the property line. To have any sort of a ramp, it has to be off our property. Like, you can't do it without either completely altering the interior of the building, or or asking the city for permission through an encroachment agreement to do it on the city's land. So this is a hardship situation because you don't have the normal room. If this was a place that had a setback from the normal property line, you could put a ramp. We can't put a ramp. So this is a practical difficulties peculiar to this site. And remember, this zone is, we're talking here about a development regulation in the Main Street overlay, which applies to many zones. So it's a huge area. When you look at the hardship and peculiarities, you deal with, how much, what does the area apply to? Well, it applies to everywhere in the Main Street overlay. And this is why I think in this DC bylaw, the council was so explicit about saying, by the DO, you have the power to vary the Main Street overlay, because again, it applies to such a vast area of the city. B doesn't apply. The DO can't vary maximum height, floor area ratio, or maximum density regulations. We're not dealing with that. C, this deals with minimum site width for subdivisions, so we're not dealing with that. And then the last one is D. There should be no variance to the general purpose or the appropriate zone or overlay. And we're not dealing with any variance to the general purpose of the zone or the overlay. We're dealing with a variance to one particular regulation that is a reference to a building code concept. In fact, one may submit that granting the variance, waiving the requirement, could even further the general purpose of the zone. When we look at the general purpose of the zone, we talk about, in section 1 of the DC bylaw, it says this provision creates a unique pedestrian commercial shopping district while ensuring future development is compatible with the character of buildings with historic false facades. One could argue that waiving the requirement for a big ramp in front actually would preserve the pedestrian nature for two reasons. One, it keeps the more historic facades intact. Two, it allows the sidewalk to remain wide, so then you have the full sidewalk as opposed to a ramp type of structure would take a big chunk out of the sidewalk. Again, if the city granted it under an encroachment agreement, it would take a chunk out of the sidewalk. You'd have to walk around it. It would impact the pedestrian flow. For those two reasons, I would say that the variance, you're not seeking to vary the general purpose of the zone. Actually, the variance may further the general purpose of the zone. Now, like I said, this may have to be dealt with by Boyle Street in any event. As you'll hear, they estimated about 1% of their patients may be in a wheelchair. And they would have to develop some sort of process whereby when a wheelchair person comes, they would have someone to assist them over the stairs. Remember, we're not talking about a massive flight of stairs where it's impossible. We're talking about a stair that's about this big. And it's about they estimated, I asked them yesterday, and about 1% would be in a wheelchair, and they would have to develop a process whereby they would help a person with a wheelchair over this step. So that would have to be done. The building code may require something else of them in which they would have to deal with. But for this purpose, I think that the argument is there for a variance for those reasons. I think a variance would actually further the general purpose of this zone. It would maintain the pedestrian nature. The people at the clinic would be able to develop a system to assist people, the 1% who would come in a wheelchair, to assist them in. They would make sure they got in. And so I think a variance could be granted. In the alternative, if the board doesn't want to waive that condition, waive that development requirement, the board could simply condition compliance, and then we would have to work it out with the city as to what to do with the building code officers and with the people in the city who deal with encroachment agreements. As I said, they've already been approached and it's being considered. But if the board waives that requirement, it may make the streetscape a little more in conjunction with the architectural goals of the area. Now, I talked earlier about the deeming provision and how it doesn't apply and why, and now I want to talk about what is the impact of needing a variance. What is the scope of your analysis once a variance is granted? When you consider the variance, do you consider only the impact of the variance itself? Or do you say, well, now that you've asked for a variance, I can basically consider this like a discretionary use, and I can consider anything. I can consider all the things that I wouldn't be able to consider but for a variance because it's a health service, it's a listed use. And I'm going to submit that in a DC zone, you have to be very careful with sort of shoestrapping a compatibility analysis that deals more with discretionary use. This is rather than a variance test, which deals with the variance itself. Now, there's two reasons for that. One, remember, this is a healthcare service, and it's a listed use. So City Council has already deemed it to be compatible with the other uses listed, the other 50 uses listed in this bylaw. So you really don't want to sort of by the back door challenge the use by saying, well, now that we're going to, now that we need to deal with this step, now I'm going to say, oh, I don't think this health service use fits this area. The City Council has said it's a listed use. It does fit the area as far as it being its use is concerned. The case law isn't 100% certain on what the scope of the analysis is when you are having a variance. Like how much can you look at when assessing a variance? Do you look only at, well, let's look at the impact and the use, value, and enjoyment of the neighboring lands of the step, or the whole development? And I would submit that while the Court of Appeal hasn't ruled directly on that, there's a strong indication that while you're allowed to hear evidence about a wide range of subjects when dealing with a variance, I'll concede that, that the focus is supposed to be on the actual variance itself. Is that variance going to be impactful? And for that, I would direct your attention to a case that you know well, the City of Edmonton Library Board and City of Edmonton case, which is the Court of Appeal's most recent discussion of this board's variance power. Just for your all reference, it's 2021 ABCA 355, a case well known to many of the lawyers here in the room, as they were all, half of them were on it. And as they talk about the variance power, I'll just read to you section 55 of this. And they talk about how the variance power, you have to first focus on what type of development regulation are you waiving, because that case was about separation distances. And they said, well, you know, how you approach it depends on what kind of a development regulation you're dealing with. So already they're talking about the focus is on that type of regulation, the regulation being waived. And then in paragraph 55, the Court of Appeal wrote, fourth, in formulating its opinion regarding the proposed development, and the opinion they're talking about is what is the impact and the use, value, and enjoyment of the neighboring lands. Fourth, in formulating its opinion regarding the proposed development, an appeal board should assess the scope and substantive impact of the requested variance, since they will be directly related to the potential negative effects of the proposed development. It is true, when you look at the bylaw in section 11, which just copies the act, it does say the impact of the development. It doesn't say of the variance, it just says of the development. I would submit, though, that it's implied in that because you're dealing with a variance, that it's the development as a so far as it's non-conforming. Because it would be, consider a situation where you had a development that was for permitted use, it was on all fours with all the development regulations, but it needed a 1-inch variance on a rear yard setback. Does that suddenly mean that now everything else is totally open for consideration? Or did you look to see, well, what is that 1-inch setback going to deal with? Here, the only issue of the variance is the step. The only people affected, the people most negatively affected by the step is Boyle Street, because they would love to have a ramp. They would love people to be wheelchairs to be accessed more easily without having to have like a bell and an assist system or whatever they would have to have. They're the ones most affected. The neighbors aren't affected at all by that step. It's Boyle Street that's most affected by the step. In fact, leaving it there allows the current facade to remain more consistent with the neighboring land. Like I said, that step is also in front of the bookstore. And again, to continue with that paragraph, it says, in making its case for a variance, an appellant may refer to or lead evidence regarding the proposed development generally, which was done, and how it relates to the development standard for which a variance is sought. So again, while you can lead evidence generally, the focus is supposed to be about, as it says, quote, the substantive impact of the requested variance and how it relates to the development standard for which a variance is sought. So I would submit that the Court of Appeal is directing, and the clear implication is that when you do look at a variance, the scope of your focus anyway, the focus should be on the variance itself. In which case we're dealing with a variance that deals with something which impacts the proponent much more than it impacts the neighbors, because they will have to deal with this. Like I said, they may have to deal with it by way of a building code change in any event. But the easiest and the simplest and the cleanest would be if the board simply waived it, and then that can stay the same, and Boyle Street just has to deal with that 1% and how they get them in. So I want now to talk about if the board disagrees with my last submission and thinks, no, we want to look at the impact in general. We think we can sort of treat this as a discretionary use, which I submit that you can't. But if the board does, we have had a lot of evidence about the impact. And you'll hear more about this when the people from Boyle Street talk. But I'm going to submit that the impact is going to not be negative, that there's no evidence that's going to be negative, that we have already heard evidence about significant problems caused or attributed to, I won't say they're caused, but people have attributed to the operation that the mustard seed operates, which is one block to the east and on the other side of the road. First, that's not, that is a different use. That is a drop-in center. It doesn't have, it's not a health treatment center as this one's going to be. It's a different type of development. So it's not fair to say, oh, we think that development has caused problems, therefore this one will as well. Two, we heard many of the residents talk about the troubles that they currently have. And one can't help but hear those and feel sympathy for them. Of course I do. Everyone does. I mean, they've talked about real problems that they've had running their businesses with the issues of social disorder. And I feel for them. I really do. But I don't think this development is going to worsen it. I would submit it's going to help it. This is a supervised consumption site where people are supervised. It's about trying to help them. Do you want them, quite frankly, shooting up on the street or in a supervised site? Do you want the needles being disposed of by a registered nurse in accordance with all of the issues dealing with biohazard sharps, or do you want them discarded on the street? This is going to, there's always a problem there now. The reason they want this, Boyle Street wants this here, is because it's a problem. We're not going to put, the location is important. There's an issue here. This is where people are. You heard the evidence from the appellants, some of the appellants yesterday, about the issues that exist. Well, that's what they're here to help. The Boyle Street Society isn't there to make problems worse. They're there to make problems better. They're trying to assist. This whole thing is about assisting this problem. It's about helping the neighbors. It's about having the security. There's an issue of someone saying, why do I want to have a place that has security guards to deal with issues that could happen? And then afterwards, they talked about how many problems they have. Well, maybe if there were people there who could deal with that, security people who would be there, it would help. I can't see this about being anything but of an assistance to this neighborhood. Very briefly, there was a mention of a report produced by the Alberta government that one of the appellants referred to. which was the Impact of Socioeconomic Review of Supervised Consumption Sites in Alberta from March 2020. All I'll say about that is that this development was designed in response to that Alberta government report. The Alberta government is providing the funding for this. The Alberta government's funding this. This is part of the province's approach to dealing with this problem, to helping these neighborhoods. I want to speak briefly about some comments that were made that that perhaps City Council didn't consider this when they defined health services. Well, maybe they didn't when they defined it a long time ago, but it was front and center when this bylaw was passed, the DC bylaw. The DC bylaw 19988, which is what we're dealing with today, and you'll hear Mr. Elliott Tanti talk about what was spoken at that bylaw. It was passed January 2023, and the very issue, people were saying you have to make an exception to health services so that you can have, we can exclude a supervised consumption site, and no changes were made. So it's not that this issue wasn't before City Council. Now, I will submit to you that as a legal position, that doesn't matter whether it was or not. Legislation, all legislation is determined and interpreted solely on its words. City Council speaks only through its bylaws or resolutions. I only mention that, Mr. Tanti will speak to it very briefly, only mention it because it had come up yesterday that, oh, City Council didn't consider this. They did. It was before them. They passed this bylaw. There was a submission made yesterday that harm to the neighborhood from a variance or from the development could simply be its perception. I would submit to you that perception is a market issue. It's not an issue of actual compatibility uses. It may deal with market value, but when we're dealing with are these uses compatible, it's something that could, I think, quickly be ameliorated if this development assists that perception could soon be reversed. And even if it's there now because of the development that we've already talked about at the drop-in center at the Mustard Seed. There apparently already is, or there's alleged to be issues of disorder. So how would this alter it? It would, like I submitted, only make it better, only assist in the situation. So with those comments, I think it's now time to hear more precisely about what this development does, what's going to happen there, and you'll see the use is a pure health service use and how we're going to help this neighborhood. So with that, I think we will ask from Boyle Street, Ms. Adaricio to come forward and go through the presentation that she's prepared. I believe it's a PowerPoint, though I think it was given in a PDF form because the PowerPoint didn't load. Before we go there, Mr. Walkowicz, I'll just see if there's any questions
absolutely,
for you.
Yes.
Any questions? Ms. Solis?
Good morning. There are two paths that you've outlined for us, and they were mentioned yesterday as well by the city. Does your client have a preference to a condition or a variance? Or waiving a
Yeah,
requirement?
I think that the easiest way, the cleanest way is the variance. But because it just makes it easier from a development point of view, because then that doesn't have to be complied with under the development permit. Now, whether it still has to under a building code permit is another story. But I think it's the neater thing cleaner for this approach. But in the alternative, a condition would also work. But I think our preference would be the variance.
Thank you.
Any more questions for Mr. Walkowicz? Ms. LaPro?
Thanks. Yesterday, when we were hearing presentations,
We heard a little bit about how illegal drug purchasing would have to occur for users of the site to even get to the site, where it may be federally approved and not criminal to use those substances on the site. However, there would be illegal activity that would have to be a precursor for users to get to the site in the first place. I'm curious if you have any comments about the SDAB's authority in that regard, in that, I mean, obviously we're governed by the MGA, but there's an implied criminal activity that would have to occur before, you know, a permitted activity on the site. Do you have any comments on that?
Yes. First, the whole concept of the medical exemption under the Federal Act contemplates that it will have been, the controlled substances will have been obtained in a manner not authorized by the Act. That's the whole point of it. I'll just read again section 56.1 sub 1A, when it says that the exemption is necessary for any person or class of persons in relation to a controlled substance or precursor, quote, that is obtained in a manner not authorized under this act. So the whole point of it is these people already are in possession. Now, how they got it probably, almost certainly, in a manner not authorized under the act. That is what these developments are for. Therefore, they have them already. They're in possession of them. They're in possession of them in a manner not authorized under the act. The whole point is this development is entirely legal because it deals with people who have obtained it in a manner not authorized under the Act to then go to a supervised consumption site where therefore no offenses they're exempted from that. So Section 56.1 contemplates that all those drugs will have been obtained in a manner not authorized by the Act. That is part of the scheme of the Federal Act. And so for this board to say, well, I don't like the fact that they were obtained illegally, so we're not going to allow this, would be in effect to try to repeal Section 56.1 of the Federal Act. And I think that would be outside your jurisdiction.
Mr. Corbell.
Yes, yesterday a number of people spoke about the consultation process that took place prior to this development being approved. You mentioned this morning something in the federal role about a consultation process. Is that expected to take place if the development were to be approved? As about dealing with compatible uses in the area where a supervised consumption site is. Yeah, the federal process contains they have their whole application. It's like any other application for a permit. This thing to operate, we need provincial permits, we need municipal permits, we need federal permits. But to talk to your question exactly, subsection 4 of 56.1 of the Federal Act does include a federal notice provision. Sub 4 says the minister may give notice in the form and manner determined by the minister of any application for an exemption under subsection 1. The notice shall indicate the period of time, not less than 45 days or more than 90 days, in which members of the public may provide the minister with comments. So it contemplates that. Now, it is entirely within the purview of the federal government, the extent that the manner and the form that they do their consultation. So the federal government does it and sets it. But yes, subsection 4 of 56.1 contemplates a 45 to 90-day period of time when after a notice is issued that the members of the public may provide the minister, the federal minister, with their comments.
Yeah, so just to follow that up, so there is definitely an opportunity for members of the public to have another shot at this if this development is approved.
At the discretion of the minister, yes. The federal minister, yes.
Yes, okay. Thank you. Mr. Jones?
I'm just curious, with the existing sites, what was the form of that consultation?
with the consultation that's happened already. I'm going to get Mr. Elliot Tanti. He has all the information about the consultation. I'm not 100% familiar, but I'll get him to talk of two questions about consultation. So he's going to come forward and he'll deal with, he'll make sure he answers your question.
Okay, sounds good. Thank you.
Thank you. Yeah.
Just a couple questions from me, Mr. Walkowicz. They relate to the variance predominantly. I understand your point that the barrier-free accessibility is also a building code dimension, has a building code dimension, but it seems to me that this is also a development regulation because of the intent of what they're trying to accomplish on this pedestrian-oriented street. It sounds like they want to create a street that's accessible, that's some sort of a commercial corridor. Can you speak to the impacts from that perspective, how not having this principal entrance be barrier-free and taking your preferred approach, which is to grant a variance to that regulation, what would the impacts be from that perspective?
I think the impact there would be two impacts. Like, let's say you had the barrier-free right in front, so you put a ramp there in front. The positive impact would be that anyone in a wheelchair would be able to access the subject site. That's the obvious benefit, right? So that anyone who's in a wheelchair, you don't have someone waiting. I guess if I could think of the negative impact would be, let's say you had to rig up a bell system, there could be someone in a wheelchair waiting for assistance to get over that six-inch step, or whatever height it is. I don't know exactly 6 inches, so yeah, I guess that would be the negative aspect, is you would potentially have someone wait until someone could come and assist them. The positive side would be having a significant structure on the sidewalk could almost do the other way of impeding the flow, the pedestrian flow. Like you said, I agree that it is a development regulation. What I really meant was the exact dimensions and all of that isn't part of the development side. That's more the building code side. Just the existence of undefined, accessibility. Like the exact words here, so I don't misquote. Yes, designed for universal accessibility is what the development side is. It could have a negative impact on the pedestrian flow of this area, and it could have a negative impact on the uniformity of the facades. When you have a group of facades lined up along a sidewalk in a property line, a structure that juts out in front of that can sort of alter that look, that facade. So I think the variance cuts both ways. The negative side, a person might have to wait until assistance, and the positive side of the variance is, besides being sort of neater, it allows for more pedestrian flow and it allows for uniform facades.
Okay, my second question is in relation to the variance, limitation to variance. You cited the hardship aspect, and this board dealt with that in SDAB decision D-21-162. It was in reference to a signed charter bylaw in February of 2021, where the wording of that limitation changed from must to shall consider issues of hardship and those associated limitations. So at paragraph 63 of that decision, it said the amendments that had the effect of changing the wording from that section from a variance shall be considered only in cases of, and it now reads a variance may be considered in cases of. Does that change your perspective as to whether or not this board would have to consider issues of hardship, or is that SDAB decision saying what that SDAB decision generally says that it's a vestige of an old bylaw and it no longer really applies? Or do you need some time to review that decision?
When I would look at it, whenever may is, obviously, may has always been seen as permissive, right? And so whenever anything is changed from shall to may, it allows more.
I guess my question is, do we even need to consider hardship anymore if City Council deliberately took out the word shall only be considered to now the development officer may consider? Let
me just look at it again. Variance may be considered, yeah.
And if you need the citation for that decision, again, I can provide it.
It's okay. I'll just
It's definitely lessened. I mean, it's something that would be taken into, I mean, it's still in the bylaw. They left it in, meaning that it's a factor. But yes, it may no longer be a mandatory factor. I mean, if you do change from shall, I mean, when the expression of council is shall to may, to me, it's a sign of permissiveness, and that, yes, I would agree that it's no longer as mandatory. It's still a factor when assessing, obviously there's many things go into assessing a variance, and one of the things you might consider, a development officer may consider is whether there's a hardship or a practical difficulty. But I would agree that that is meaningful. You change it from shall to may, it means that you may consider it, but you don't have to.
Any more questions for Mr. Walkowicz? Seeing none, thank you, Mr. Walkowicz, for your presentation, and we'll now hear from whoever you want to start with next.
Yes.
And you may begin.
Good morning. Thanks for giving me some time to speak about the actual operations and what we will be, what programs and services we'll be offering at the Health Hub. I do have a PowerPoint. So the presentation will be, I'll speak about what services we will be offering, what a day or what one visit from a service user would look like potentially, and how this is an actual health service.
Just give us one moment. We're just
Sure.
working to get this on the screen for you. Does that look right?
That's it. Yep.
Proceed.
Great. Thank you. If we can go to the next slide, please. Thanks. I'd like to start off with letting everybody know that the Health Hub has been gifted a Cree name by our elder, and that name for the Health Hub is Mahikan Kamik, which translates into wolf den. So wolf den introduces a flexible program model which integrates physical and mental health care provider oversight, people with lived experience, and community supports. So the Health Hub aims to incorporate harm reduction, public health, social service, addiction treatment, and withdrawal management within an overdose prevention site setting. This model will address the overdose risk posed by the increasing toxic drug supply, also offer the wraparound services that fits in line with the province's recovery-oriented systems of care. We submitted some peer-reviewed academic research, so I'd like to just pull out some points in one of the articles called Integrating Supervised Consumption Site into a Continuum of Care for People Who Use Drugs. Integrated and co-located health service models, effectively one-stop shops, could improve health outcomes for people who inject drugs by combining the prevention of immediate drug-related harms with access to primary care, mental health care, and social service programs. So while the primary intention of the overdose prevention site is to reduce overdose deaths and related harms, Further objectives include providing a low-barrier access to wraparound care, including referrals to the continuum of addiction, mental health, and physical health care services. Another study cites that there are more than 90 supervised injection sites worldwide. Vancouver's supervised injection site has been operating since 2003, and many other Canadian jurisdictions are planning supervised injection sites. These should be tailored to community needs. Services at supervised injection sites include emergency response to overdoses, injection first aid, assessment and referral to primary health care, harm reduction counseling, and exchange of needles and other drug paraphernalia and condom provisions. So these sites support users to seek counseling and detoxification treatment for addiction. So that's taken from Does Evidence Support Supervised Injection Sites? The next slide, I'd like to give a quick overview of the core team that would be on site at Wolf Den daily and what services and some of their responsibilities daily. So the core team on site daily during operational hours will have a team lead, and they'll be responsible for the daily on-site management, scheduling, medical supply ordering, data collection, and reporting. We'll have 2 registered nurses. So some of their responsibilities would be pre and post consumption assessments, basic and complex wound care, withdrawal management, sexual health testing, immunizations, prenatal care, primary care referrals, of course, overdose response, case management. They'll be able to dispense prescribed medication to service users if they need, support and liaise with pharmacies, and pregnancy testing. We'll also have a social worker and support worker on site, and they'll be able to access housing workers, detox beds, financial needs, psychological needs, and cultural needs as well. They'll be able to provide referrals. We'll have a mental health and addiction support worker. They'll be responsible for on-site programs, relationship building with the service users, which is a core part of what this service will be doing. Harm reduction education. They'll be able to provide referrals and walk through service users with the virtual opiate dependency program, overdose response, and mental health support. In our community consultations in the past few months, we heard from the community that there was concern about the impact the service would have and our accessibility to address emergent issues. Therefore, we committed to creating a specific position to respond to that. So the specific job is the intensive support worker. So the responsibilities of the intensive community support worker would be to engage with businesses and residents. They would be able to run the community action team. They'll do neighborhood walks, address community concerns, and of course assist in overdose response if needed. And there was talk about, of course, we'll have the security guard on site to provide on-site de-escalation if needed. They'll discourage loitering if people start congregating. They'll try to discourage it. They'll do timed neighborhood walks, and they'll also assist neighboring businesses in de-escalation within reason if needed. The next slide. I'm going to talk a little bit about the weekly program staff. So people that don't work for Boyle Street Community Services that will come in and provide services and what that'll look like. So physician or a nurse practitioner, so they'll provide emergency care, physical assessments, referrals to detox and treatment, withdrawal management, referrals to primary care, and medication prescribing. We'll have a housing worker, a housing first worker. They'll have access to housing lists, assist with accessing financial resources, assist with getting identification, and navigate all the housing barriers. We'll have cultural supports on site that will provide access to elders and knowledge keepers. We'll have access to traditional medicines. They'll provide Indigenous specific harm reduction, and they'll help with reconnection of family. We'll have a counselor, a therapist on site. That person will do one-on-one and group counseling. They'll provide case management and, of course, referrals. The next slide, you can't really see it, but I'll try to walk you through what the interior will look like. Oh, thanks. So for this slide, I'll just let you know what each section of Wolf Den looks like, and then I'll try to walk through and give you sort of a visual of what a service user would go through coming through the site on a day. The entrance, of course, is on 81st. There's a little waiting area and reception area once you come in. On the left-hand side, there'll be an information area. So behind the reception area is the observation room. Behind that is the nurses' station and office, which will be a fishbowl. So the nurses will be able to see what's going on through the whole site. There's a touchdown for staff. The 3 consumption booths. Across from that is the exam room for the physician or nurse practitioner and nurses if needed. There's 2 offices dedicated to counseling, virtual opioid dependency program referrals, social worker, and detox triage. Staff bathroom, and in the back is the staff area. So that is sort of a quick overview on what the site is going to look like inside and the flow of it. Okay, so upon a service user's first visit to the site, so this is the first visit, they would meet with intake staff and a nurse. They would read through an agreement form stating the guidelines and procedures for the service. So any questions or concerns with the service user could be addressed at this time. So if the client agrees to the terms, they'll provide a full name and PHN. If the service user doesn't have a PHN, the staff will assist them in obtaining one. That's one of the regulations that we need to abide by through the provincial government. A code name is given if desired to preserve confidentiality. So this code name or name would be given to staff by the client at each visit before entering. So from there, the service user would enter the observation room where they are assessed by the on-site nurse. If the assessment is satisfactory and the type of substance is discussed, they are assigned to their own sterile booths. I'd like to just mention here, with Ms. Agrios, yesterday had stated there was some data with the ECC overdose prevention site data stating that meth was one of the main substances being used and others. So of course everybody is hearing about the toxic drug supply. So when service users come in to consume their substance in the overdose prevention site, what they think they purchased is usually not completely what they are consuming, hence the toxic drug supply. And we don't have testing services on site, so that's why people that our community are dying from is the toxic drug supply, and we don't know exactly what is in the drug that is purchased. So all booths are equipped with a mounted sharps bin, and service users will be given sterile and harm reduction supplies as needed. So the site will continually be supervised by staff, ensuring program guidelines are being adhered to and everyone is safe. Staff offers support in harm reduction, listening to what clients may need help with, along with safer use education. The safer use education could be staff helping clients or service users not use the same vein or injection site to, provide vein care and just how to use safely and safer. So there'll be medical response equipment such as SpO2 monitors, oxygen, naloxone, always on standby in case medical attention is needed. So once the client has completed their consumption, they're asked to dispose of their items in an appropriate disposal bin, and then they are asked again to go into the observation area. In this area, the clients have a short respite. This space is ideal for connecting with clients to discuss what resources they need. This area, so with mental health, addiction support, and social workers on site, this allows staff and clients to build trusting relationships in navigating housing, income support, medical detox, and treatment centers. So staff can collaborate with other facilities and the on-site multidisciplinary team to help guide service users through the continuum of care. This area also allows clients to connect to our on-site nurses, the physician and social worker, and build trusting relationships that could improve the quality of life of our service users. Once the assessment and the client has completed connecting with staff if needed, they are again assessed by a nurse. Once the assessment is complete and they're deemed okay to leave the facility, a naloxone kit and training will be offered to the client once they exit the service. So that's sort of, that's a really quick sort of overview on what a visit would look like in regards to using the OPS. The flex office that you see we have that there in that specific area because if somebody, if one of our community members come in and they don't want to use the overdose prevention site, it's still and they want to, check their housing list or check to see if there's beds to get into a detox, they still have some confidentiality and anonymity to be sort of separate from that. The next slide. This slide, I took the information from a really amazing one-pager. It's called WhySCS, WhySCS.ca. I would encourage everybody to go and take a look at this website. It has amazing, really, really great up-to-date information on supervised injection sites and good links to amazing research that has been done in the past, 3 decades. One of the things we at Boyle Street Community Services have been conscious of is these services are designed to meet the needs of existing communities. It's important to note that supervised consumption site services can reduce a number of drug-related harms, improve health of people who use drugs. The evidence says that supervised consumption services prevents overdose deaths with trained staff that are on site to reverse them if they happen, decrease unsafe drug use practices, so facilitate less risky drug use practices. As I mentioned, there'll be no sharing of needles, proper injection along with vein care. Decrease HIV, HCV transmission. Increase access to health and social services. So despite this is also taken from that website, whyscs.ca. Despite common concerns, existing scientific research indicates that SCSs do not increase crime and may improve public order in their neighborhoods. Supervised consumption sites are typically implemented in areas with public drug scenes and are designed to bring pre-existing public drug use inside. Thus, concerns about the potential to increase public drug use or the number of improperly discarded syringes are typically unwarranted. In fact, the evidence shows reduction in public drug use and publicly discarded needles around supervised consumption sites after they open. Decreases or no change in violent crime and no verified changes in drug trafficking. Again, all of this data can be found at whyscs.ca. I've also taken a little bit from the Health Canada website. Health Canada website states that supervised consumption services saves lives and benefits communities. Supervised consumption sites provide safe, clean space for people. This prevents accidental overdoses and reduces the spread of infection diseases. Supervised consumption sites offer a range of evidence-based harm reduction services. The sites also provide access to important life-saving and social services, including substance use treatment for those who are ready. The WHO, the World Health Organization, has endorsed them as a key public health service in response to HIV and other drug-related harms. The UN Sustainable Development Goal sets out a commitment by governments to strengthen the prevention and treatment of substance use. Several of the targets are in particular relevance to drug policy-related health issues. They especially target ending the AIDS epidemic and combating viral hepatitis and preventing and treating non-communicable diseases and promoting mental health. So my last slide. Alberta Health Services has released their data on overdose deaths a couple of days ago. From January 1st of this year to April 30th, 2023, in Alberta, there have been 613 deaths in 4 months. That's 153 preventable deaths a month, or just over 5 per day in Alberta, with the highest number of deaths between the ages of 25 and 39. Yeah, that's it. Thank you.
Any questions? Ms. Solis?
I have a couple of questions, but I'm going to start with your last slide first. When you were talking about the overdose deaths in Alberta recently, how many of those were in Edmonton?
I'd have to look at the healthanalytics.alberta.ca, but I can pull that up and get that for you. Or
that would be helpful.
Yeah.
Along the way, you talked about OPS and SCS.
Yes.
Are those interchangeable terms?
Supervised consumption sites are federally funded, and our overdose prevention site is provincially funded. So that's they're not permanent locations. So SCSs that are funded federally are permanent, and overdose prevention sites, as Mr. Walkwich had touched on, we would have to reapply yearly.
Okay.
For our license for operation.
Okay, thank you. Thank you for that clarification. I wasn't sure exactly how those two terms related to each other. Sure. Yes. Is your service drop-in only, or a combination of drop-in and appointment, or appointment only, or?
It's not appointment. No, it's drop-in only. So when a service user comes in, they can come in. They don't need to set an appointment unless it's specifically to see a housing worker or one of the counselors or when the physician is on site.
That's what I was wondering about. If because you do have some staff that are just there one day a week.
Specific days.
And are those appointment-based only, or a combo?
That would be probably a combo. It would be whatever the thank you. It would be whatever the doctor or nurse practitioner feels they need.
And the other question I have, and it's related to something I asked one of the community members yesterday, one of the appellants. What is your experience with lining up outside you have some space inside for waiting and treatment and so forth. Do you anticipate there will be regular lineups outside, and how would you deal with them if there are?
Yeah, we don't anticipate a lineup, and if there does seem to be a lineup and there's folks in the booths, there's 3 people in the booths and there's people waiting in the waiting room, we would just talk to the individuals that are inside and try to really assess what the needs are and what they need, and let them know that there are people waiting outside. But we don't anticipate a lineup outside, no.
If you did, how would you deal with the lineup itself? Would you do would the security guard be doing anything?
Definitely, yeah, the security guard would be outside monitoring it. If it becomes a problem, they would monitor and de-escalate if needed. But the facility is big enough in the waiting room and the little area beside the waiting room that would be able to accommodate people, yeah. So we don't anticipate a problem with the lineup.
Okay, do you anticipate, if it were to happen and you get, not everybody is pacing themselves, somebody coming at 10 and somebody at noon or whatever, they're, everybody lining up at a certain time. Do you anticipate using any of your side setbacks for lineups?
The site setback in the back area, you mean, or in?
Along the side.
along the side. Nope, no, we don't anticipate using that. It's very narrow and really dark between the two, so I wouldn't want anybody lining up in that area. Really, the demographic and the amount of individuals that would be using the site would be minimal, really. We anticipate, you know, on average, I mean, it's hard to say on average, but not a whole, people from, so it was brought up that the inner city in downtown, in front of Spady and in front of Radius Healthcare, there's always folks around and lining up for it. That's it's a different demographic. It's condensed. There's research that shows that individuals that are in the inner city and are they use substances, they won't travel more than 10 minutes to get to an overdose prevention site to consume any sort of their substance. So for a lineup, we would bring folks inside as safely as we could, especially in the winter. We wouldn't want people standing outside to come in if they're there not to use the overdose prevention site and want to meet with a doctor or the VO DP, we would bring them inside. So yeah, we would bring, it wouldn't affect the service, and it wouldn't, having a lineup, we would bring as many individuals in. Like I said, it's a fairly big entryway, so we would bring the individuals inside, especially if it's winter, and with a security guard on site. We don't anticipate any sort of de-escalation or problems that way.
Okay, thank you. The other thing I'd like to ask about is you say that these centers are evidence-based, that you choose a location based on, you know, some needs assessment so that there's some, you're aware that there's some public drug consumption or activity in the area. So that was part of what you assessed in this situation.
Yes.
But yet you don't feel that there will be lineups, and then it's serving a different population than the ones downtown.
The acuity in downtown is much higher than, so when we did our assessment in the area, there has been an increase at that point, that was last year, but every week there has been an increase in drug-related calls to emergency services. And I also did my own sort of ethnographic research. I went with some and sat with outreach workers and talked to the community to ask what the needs were in that area specifically. And the main thing was an overdose prevention site with services attached to it. In regards to, did that answer your question?
Okay, yes,
Sorry.
thank you very much.
Okay. In regards to the number of deaths in Edmonton in the 4 months, it's 197.
Ms. LaPearl?
Thank you. Hi. So I have a question about the health services that you're providing. My question is everyone who attends the site receiving a health service? Some obviously are. They're getting wound care, they're getting overdose prevention, addiction counseling. I suppose what I'm asking is everyone who uses a substance on the site, maybe that's all that they do, are they all treating a health condition if that's the only thing they're doing?
If they're only coming in to use the overdose prevention site?
Yes, but all they're doing is consuming the substance and they don't necessarily have an overdose or receive counseling. Is that still a health service?
Yes, it is. We are keeping people alive, essentially, and we're they're not sharing needles, they're not in the back alley using puddle water to, so yes, it is.
Yeah, and I'd just like to add to that, all those sort of letters from all the medical officials in the city, that is what they're getting at, is that is itself a health service. It's not that, oh, these are health services and this is the supervised injection. The supervised injection is the health service. It's part of an integrated health approach to dealing with people suffering from addictions that involves both supervised consumptions, access to referrals, access to nurses. It's one continuous health service dealing with a demographic that has significant problems with substance addiction. And that was the what all of those medical letters were from the both regular physicians and also physicians with offices for the health department, is the health service. So yes, the answer is 100%.
Thank you. I have a second question. You talked a little bit about reducing drug-related harm, and also drug supply in that it's poisonous. So I'm curious about no drug testing on the site. Can you maybe tell us more about why there is no testing of the substance?
We would have to, it's an Alberta Health Services or Alberta Health funded thing, and we would have to get approval from Alberta Health Services to be able to do that.
Any more questions? Mr. Jones.
First of all, thank you very much for the work you do. A couple questions about this site specifically. What kind of hours and days of the week do you plan to be open?
7 days a week. We will be operational 8 a.m. to 10 p.m. Staff will be on site from 7 a.m. to 11 p.m., including the security guard.
Okay, and you mentioned that you do not anticipate testing drugs. Is that something that you're working towards?
We would love to be able to do that, yeah.
And I think the question about this site was asked, so you chose this because you feel there's a need in that immediate area? Is that correct?
Yes.
And what kind of expectations do you have as far as the numbers of people? I mean, I know it's hard to put an actual figure, but you must have some idea as to what you would expect as far as, we'll call them customers, I guess.
Yep. We expect, if it's unique visits, we could have the same individual come in 3 or 4 times a day. But unique visits, meaning the same, just separate visits, probably we're anticipating, 40 to 50 visits a day. It could be the same individual coming in 3 or 4 times a day. So yeah, it's really, it's hard to anticipate with, it's really.
Okay, I guess one of the questions I have is, so what happens when they leave? So somebody comes in, they take whatever the product is.
Yep.
I take it they sit for a while you observe them, and then they leave, but they're high. I'm guessing. I don't know for sure, but I'm guessing they're high when they leave. So what kind of experiences do you have with that? Because you're sending them out the door into this neighborhood now.
Yeah, I've had lots of experience with that. So there's a high misconception that when somebody comes in to use an overdose prevention site, that they leave and they're cognitively sort of not being able to, realize the world around them or make decisions, and they're stumbling. And honestly, that's not the case. If they were that way, we would 100% not let them leave that way. If, we were, methamphetamines has been brought up numerous times yesterday with the appellants and psychosis and people that are violent. I worked in Vancouver's downtown east side for over 2 decades and here, and it's just, the evidence isn't there. It's not true. If somebody was in an agitated state and were in the facility, and if we felt they were getting violent and staff and security guard weren't able to de-escalate the situation, we would call 911. We would never let anybody leave in that state. They would be a danger to themselves. And we're there to provide services and keep people safe. So the nurses would, and the medical staff on site just wouldn't let an individual leave that way. And, the individual that is coming in to use the site, they're going to use anyway. So it's better that they come in and they're assessed before they leave the facility instead of using and just there.
It was mentioned, I think, with one or two of the appellants that these sites can become a magnet, not only for the users, but
Yeah.
drug dealers.
Yep.
What's your experience in that regard?
Yeah, and that's definitely a valid concern, and I would also be concerned about that if I was a business owner or a resident, but why we're there is we're there because the individuals are there already, so they're purchasing their substance however they're purchasing it already. And there's research that shows that if you're going to use a substance, and if you're a substance user, you're not going to travel over the bridge. You're going to use, you're going to use within a time frame, especially if you're sick in the morning and you wake up and you need something. You're not going to travel a long distance to be able to feel well again.
So most of the people that would come, they'd come on foot. They're not. Mm-hmm. Okay.
Yeah.
Now, the model that you've laid out here, is that the same model employed in the other sites? As far
The
as
George
staffing?
Spady and, staffing?
Yeah.
Well, medical staff on site, yes, for sure.
Okay. How about the community support aspect? Because you're mentioning here that you would have somebody checking with the local businesses, whatnot.
Yes.
Does that happen in these other sites?
It does not,
Okay.
no. Not that I'm aware of.
Okay. And I guess just with the other sites as sort of a template or as to what's happened, have you made some mistakes there that you would like to change in the operation of this site, or how do you see it operating in a similar fashion? Or
I truly, I'm a terrible public speaker, and I was, slightly terrified to come up here, to be honest, but I believe that this program, with medical on-site, with cultural supports, and, therapy and access to housing, and we'll be triaging for detox and treatment beds every morning, it's the first of its kind really in a sort of, that I'm aware of in Edmonton. And it's going to be successful. It's going to take public drug use off of the streets, and it's going to house individuals. And the bottom line is it'll save lives. There's 197 people, individuals, human beings died in the last 4 months just in Edmonton. So if
okay, and can you speak to your success rate in getting people off of drugs through this mechanism? Because people are coming in, they're using.
yeah.
I'm sure it's ongoing, but do you have any ideas to how many people are actually going into detox and then not continuing with drugs?
So that's a really complex question to answer. The wait to get into detox bed and treatment right now is quite long. So the window of opportunity is short. So that's why we will be partnering, hopefully, we're in talks with George Spady to be able to triage folks daily to be able to get them into detox and treatment in a timely fashion. So it's really, really difficult to answer and give you a number and be able to attain that. It has so many complex barriers and other needs to be able to.
Sure,
to give
no,
you a
I
number.
understand. Thank you very much, that's all I had.
Sorry. I just have a couple questions. I understand you have to satisfy the minister that that you've got the right supports and everything in place, and we're
Yes.
trying to make a decision about potentially impacts depending on how this use is characterized at the end of the day. My question is, what if what you're expecting, the opposite happens, and the impacts that these businesses are concerned about actually do materialize? What kind of recourse is available to these people to then get rid of a use that is now creating the impacts that were anticipated? And it might be a question Mr. Walkwich will probably want to chime in on, but is this a type of permit that can be time limited? If so, is that something you would entertain just so that these impacts could be better assessed?
Yeah.
Or it's a big bundle of questions there,
Sure,
Mr. Walkwich. I'll let you untie 'em.
I'll let Boyle Street answer part of this. I'm going to step in for where I think you're going, and then we'll go to where he's going. Is that there are, and I think what we're going to hear from Boyle Street is that the provincial and even federal regulations do have time limits and reassessments, which I think we'll hear. I think, but before we hear that, I think there was some comments about time limiting a development permit. I think that would be varying this bylaw, so this permit significantly in a DC thing. I don't know if that's open here. I also think it's not necessary, given that I think we're going to hear about the provincial and federal regulations that have more a constant assessment by people who deal with these type of sites all the time and assess them. But I'll let you answer now. Sorry.
Yeah, no, that's fine. Yes, so if we do get the exemption and the license to operate, it's conditional, it's 6 months. And after that, it would be yearly. We would have to apply yearly. And our responsibility to the ministry is to provide reports and feedback from community. And one way we're doing that is we're going to have a community action team, and that would I hope, and in the past it would involve business owners and residents and staff at the OPS to really come together and talk about trends, what we're seeing, what's happening. So we want to be transparent, and we will of course be honest in what's happening and in reporting to Alberta Health.
Any further questions? No, seeing none. We thank you for your presentation and for appearing before us today. Mr. Walkwich, who would you like next?
Thank you. I think we'll go to Mr. Croy Johnston, who hopefully is online from London, England, so he can probably get to his supper, because it's probably close to dinner time there. Mr.
Hey guys, yeah. Hey, can you guys hear me?
We can. Yep. Please proceed.
Yeah, sounds good. Yeah, thank you, Ian, and the SDAB board for letting me speak today. Just a minor correction. I'm not an architect. I work for Beljan Development. I'm an urban planner on the team, but I've been working with Beljan for roughly 5 years now. So Beljan Development, as you guys know, is a local developer with a long-standing presence in the Strathcona and Ritchie area. We have completed numerous commercial and residential developments in the neighborhoods. We acknowledge that homelessness is a citywide issue, and we support Boyle Street's mission to ending chronic homelessness in Edmonton. We recognize that achieving this mission requires a range of approaches, including community centers, health hubs, and partnerships. Over the last several years, Beljan has worked closely with Boyle Street to develop these new sites for those they serve, including Strathcona Health Hub that we're discussing today. So while my other colleagues have covered various aspects of Strathcona Health Hub, I'll be focusing on our alignment with Strathcona, the Strathcona Area Redevelopment Plan, and the details of a barrier-free entrance if that was a requirement. So to begin, the Strathcona ARP places significant importance on preserving the heritage-defining character and its relevance to the neighborhood and area. In the development permit for the site, we not only acknowledge that these character defining elements, but we also aim to enhance them through minor exterior alterations. These limited alterations will maintain the architectural character of West Ritchie. West Ritchie is known for a unique blend of commercial, industrial, residential, and institutional land uses, false front architecture, and a history of German establishments. The Strathcona ARP encourages West Ritchie's transformation into a vibrant, historically referenced urban village with high-quality urban design and architecture. The presence of false fronts along 81st Ave, which are consistent throughout, has been showcased in my submission package provided. The Strathcona ARP addresses these issues by the following provision. 81st Ave between 101 and 102 Street has a unique character due to its vista to the historic CPR station and its concentration of buildings with historic false front facades. Development pressures threaten this character. The ARP established policies to combat that issue. So one is to maintain the unique character of 81st Avenue between 101 and 102 Streets. The DC1 provision will maintain the false front facade character of this area and seek to preserve the view to the historic CPR station to the west. Secondly, policy number 2, the creative retrofitting of existing buildings is encouraged. Overall, the site does not contemplate the heritage character of the avenue. It adheres to the principles outlined in the ARP, which further demonstrates our alignment with it. One thing I'd like to quickly touch on is the general purpose of the DC1 bylaw. In many urban and commercialized areas throughout our city, these areas are serviced by a variety of different forms of health services. Fundamentally, health services are an essential part of urban living, and all Edmontonians are entitled to appropriate access to healthcare. The City of Edmonton has undertaken a multi-year project to promote and build the city plan, which entails the community of communities, in which people can meet many of their daily needs within 15 minutes. With this in mind, we should consider that health services will continue to be present throughout our communities in many forms, if that be a neighborhood or a Main Street urban setting, and we cannot marginalize the specific health service given a perceived notion of the clientele using that service. Overall, the site preserves the heritage character of the avenue. It adheres to the principles outlined in the ARP and follows the general purpose of the DC1 zone. So now I'd like to explain a few nuances regarding the Strathcona ARP, the CB2 zone, and the Main Streets overlay. The West Ritchie area, as specified in the Strathcona ARP, states the following provision. And historically, DC1 direct development control provision based on the CB2 general business zone as modified by the Main Streets overlay will be applied to maintain the unique character of 81st Avenue and 101 and 102 Streets. The DC1 provision will maintain the false front facade character of this area and seek to preserve the view to the historic CPR station to the west. The site is based on the CB2 zone and the Main Street overlay. However, the Main Street overlay, specifically section 819.4, comes into effect when there is an exterior alteration of a facade of a principal building. In efforts of being a Class A permit, we are enlarging a window, which we must comply with this section 819.4 and will comply with other various MSO provisions, including the following one. Where a commercial use is provided at ground level, abutting a public roadway other than a lane, the principal entrance shall be designed for universal accessibility. A maximum of 2 ground floor commercial units may share a common entryway. As you are aware, there was an oversight by the development officer regarding our initial application. Although not illustrated on the development permit drawings, it has always been our sincere intention to make this building barrier-free. We originally planned for the barrier-free entrance to be from the back, but through engagement with the EPS and other stakeholders, we decided to change the primary access to the front facing 81st Avenue. With that change, it led to an oversight by the DO. From there, it was acknowledged by the DO they could stipulate a condition to make it barrier-free, in which we have always agreed with. We recognize that inclusivity and accessibilities for all individuals are essential, and our aim is to best serve our clients. being accessible and usable to the greatest extent possible by all people, regardless of age, size, ability, or disability, is not merely a design requirement, but a fundamental condition of good design. Mr. Walkowicz has explained in greater detail, we have proposed a condition or a variance on the development permit to ensure compliance with the Main Street overlay development regulations. We have planned, if a condition was chosen, we plan to achieve this by constructing a ramp that provides universal accessibility to the primary front entrance of the site. We have submitted preliminary plans of how we would achieve this barrier-free access. The ramp will be designed according to the Alberta Building Code and will be reviewed by a building code officer to ensure its compliance. In addition to the ramp, I should note that currently the inaccessible entrance is within city right away, and we would likely need an encroachment agreement. These applications happen very often, and given the purpose of creating a more accessible environment, it likely would be encouraged and supported by the city. Furthermore, we will ensure that a minimum clear width of 1.8 meters as per the City of Edmonton construction and design standards would be maintained. Fundamentally, if the condition was granted and the ramp is approved, we're making a character building on a pedestrian street accessible for everyone, which is an improvement to its current standard. So thank you for recognizing our perspective and acknowledging the efforts we've made to align with the Strathcona ARP and the MSO, as well as addressing the site accessibility requirements. Our commitment to the community and the overall success of Strathcona Health Hub is clearly demonstrated through these actions, and I do welcome any questions. Thank you.
Thank you, Mr. Johnston. Any questions? Ms. Solis.
You've indicated, and the supplemental drawings also indicate the solution would be a ramp. Have you considered just cutting the door down to the pavement level, to the sidewalk level?
I think that has been considered in some capacity. Has it been looked at in further detail? No. It could be something that we could look at in greater detail if that was essentially provided. But we do feel that the ramp is probably the best solution.
And do you have a justification for that? A ramp over a roll-in entrance?
I think just given the current infrastructure of how the existing building is laid out, it would just, like under the building code, there's certain slopes and certain depths of how a ramp has to be basically aligned. The building, although if we cut the door down to a certain level to the street level, that building still has a slab that is at its current level. So we would have to basically slope it from the interior to make it accessible under the building code. So has it been looked at? Not. Has it been considered? Yes. Has it been looked at in greater detail? No. And that's given just the current design of that existing building.
Okay, thank you. I understand you'd need sort of an interior ramp as opposed to an exterior ramp, is what you're telling me. Okay, thank you very much.
Yeah.
Anything further? Seeing no questions, thank you, Mr. Johnston, for joining us. You may now go enjoy your dinner.
All right.
I think we're just going to take a break, Mr. Walkowicz. We've been sitting for a couple hours now, and I think everybody wants to stretch their legs. So let's take a 7-minute break today because I'm feeling generous. We'll come back at 10:40 and we'll resume with the next individual on your list. Thank you. We'll just wait one moment. I don't believe Ms. Agrius is back yet. I'd like to make sure she's around. Okay, I think everybody's back. Mr. Walkowicz, the floor is yours
Thank
once
you.
more.
Thank you, sir. After Ms. Adaricio was asked certain questions, we thought that we could expand on some of the answers given and perhaps be more fulsome with another person from Boyle Street. I have one of the registered nurses from Boyle Street, Ms. Marlis Taylor, who can both describe her role at Boyle Street and then can provide some comments to perhaps clarify some of the questions that were asked.
Certainly. Please proceed, Ms. Taylor.
Thank you so much. My name's Marlis Taylor. I am a registered nurse. I've been a nurse in the downtown core now for 28 years, which is distressing to me, only because most of my staff weren't even born when I started. Anyway, some of the other roles that I have right now is that I'm the chair of the Canadian Drug Policy Coalition. I was a member of the Ministers' Opioid Emergency Response Commission and a member of the Alberta Health Services Board of Directors for 4 years. So I know this area very, very well. And there were just some questions. Some of them were historical in nature. And so I just wanted to be able to answer a little more fully around some of those historical pieces, for example. So one of the questions that had come up was around what happens when people leave. And so what I do want to tell you is that this is our 4th overdose prevention site that we're running. We had the original one at Boyle Street Community Services. We had one at the temporary shelter at the Edmonton Convention Center. We had another one at the Commonwealth Stadium. And so now this one's number 4. One of the things that we did learn right off the bat is that when people leave these sites, they are in a very different place than if they had been using on the streets, and there's a reason for that. In the world of substance use and harm reduction, there are 3 things that impact on how someone will react to a drug really quickly. One is, what is the drug? Unfortunately, people don't know what the drug is these days. But different drugs have different effects. 2 is how that person is physically. That's called the set. And so how are they mentally? How are they physically? What's the cultural piece of this? How much tolerance do they have, for example? The 3rd piece is the setting. So what's going on around them? You know, are they under extreme distress about one thing or the other? So, you know, an example on this would be alcohol. Alcohol is the same. However, some people will drink and some people will cry. Some people might fight. Some people might laugh. Some people, you know, might just relax. So different drugs, it's more than just the drug that has the impact on the person. So when someone is using in a back alley where they may be cold, frightened, hungry, thirsty, up all night, under extreme distress because of living in poverty, all of those sorts of things, they have a certain kind of reaction, perhaps. When someone comes into a supervised consumption site, and what we learned really quickly was when people come into a place where it is well lit, where they are warm, where they're offered something to eat and something to drink, where there are people there that welcome them, then their reaction to those drugs are very, very different. In the whole time that we had those sites, only twice did we ever feel that we had to call the police. It is not that people use the drug. The myth is that someone will use a drug like methamphetamine and suddenly, you know, lose their mind, if you will. That's actually not the case. That's not what we saw, and that was one of the biggest learnings. So by treating people with respect and with care, we actually had much better responses for people from the drugs that they were using. Another question that you had was, what lessons did you learn, you know, from the other sites? And I think that what we learned is simply that, is that people, when they come out of these sites, have a different view on themselves and on the world, and they are less likely to cause any kind of problem. And I can say that certainly when we had the Commonwealth Overdose Prevention Site, you know, that was sort of the first one that the current government, provincial government, was involved in, and they certainly insisted on, you know, lots of community, chance for community to provide feedback. We had ongoing meetings with the community. We had emails, and I think there was a phone number that people could call if they had any concerns, and we never had one call the whole time. We never had anything raised in that whole time frame. And so to me, that told us that we did this right. And I have to say, after all of my years downtown, when I looked outside, if I compared when I was at Boyle Street from a year before we started the supervised consumption site to the year after, there was no difference. The people were the same, and probably the quietest place in the whole building was always the supervised consumption service, actually. People were happier, they were quieter, it was a much better environment. Where things all changed was with COVID, and when homelessness sort of went through the roof, then we ended up in sort of this very different situation, and one that's not even really recognizable to what it was at the time. And then you had asked the question about success. First of all, what is success? Is it someone becoming more stable, which we have seen lots of? It's also understanding that sometimes with substance use, when people quit their drugs, they can't come back. They can't tell us what happened, because a lot of substance use is triggered visually, and so they disappear from us. So those kinds of numbers are hard to get. We do know, certainly at all the sites, when we were able to get people onto opioid agonist therapy, and that did happen very often, some people's lives completely changed. And they did move away from us, which is really kind of in a way what you want. We don't want to have this service. But so it did make a big difference. But that's not for everyone, because everyone has sort of a different time frame, and they have different stressors, and they have different reasons why they're using those substances. However, for those that are ready, and by then the staff get to know people, they are watching for those cues, and then they're ready to go right away to help people access the services that they may need at the time. We have had a large number of people that have done well. So I just wanted to address those three, partly because they're historical, and we were very lucky to lure Cindy into this position, but she wasn't there for the other three. So. Okay.
Anything further before I open it for questions? Any questions? Ms. LaPro?
I do have a question. Throughout our process, our hearing today and the submissions we've received, we've heard from a lot of affected community members. We've heard from property owners, from lawyers. One group of people that we have not heard from is users of the site. Obviously, I know that you're not a member of that community, but if you had to guess at what a user of the site might want to present or say to this hearing, do you have any ideas what that might be?
I would say I could have been a user. Any of us probably could have, depending on how our lives went. The people, we do lots of evaluations, we do lots of checking in with people. We've done formal research as well as ongoing evaluations. We get feedback. About half of my staff are people with lived experience of using substances. So they bring a certain richness and depth to the work that's just amazing, because they're very quickly aware of when things are not going well for people. One of the groups that we do a lot of work with is AWARE, which is the Alberta Alliance, who educate and advocate responsibly. That's a group of people who use or used to use substances. They're very much involved in everything that we do. We take their feedback. They give us ideas. Even on our in our site at Boyle Street, there was a board on the wall, write your suggestions. And so people would write down, what they thought we should have, and whether it was, more cookies or, or longer hours. Typically people want longer, they really find this a valuable service, and they want more of it, actually, more than anything, yeah.
Anything further from Ms. Taylor? Seeing nothing else, we thank you for appearing before us today and for your submissions.
Thanks for your indulgence.
All right, the next person we'll have also from Boyle Street is Elliot Tanti, who will deal with the promised consultation question that you asked earlier, Mr. Jones.
but would also, I think, is going to give a little bit more fulsome overview of the provincial licensing and how the province monitors, which he's the guy for that.
Thank you.
Hi, everyone. My name is Elliot Tanti. My pronouns are he, him, and I'm the Senior Manager of Communications and Engagement at Boyle Street Community Services. I've worked for Boyle Street for 7 years, and if there's one thing I've learned in my time there, Marlis Taylor is always very difficult to follow, but I will try my very best. One of the things I wanted to address right away was an interaction between the board and Mr. Walkowicz regarding oversight of this facility, and Mr. Walkowicz referred to federal legislation. This site itself is actually governed by provincial legislation, so while much of what he said is true, he was referring to a federal minister. It's actually a provincial minister of addictions and mental health that will be ultimately overseeing this, making the determination about whether we get the licensing or not. One of the questions also that emerged was about accountabilities. And what I would say is the regulations and requirements related to this site are probably the most stringent in the country. Our provincial government has been really direct that these services are provided in a certain way. And so one of what we are required to do is provide regular updates to community on impacts. We have a good neighbor commitment that was made in concert with community that we have to adhere to and that we are judged based on. And we also have data that we also provide that annually that will provide, the provincial government will use to make determinations related to licensing as well. The other thing I wanted to address was when this bylaw was passed, and Mr. Walkowicz referred to it in January, I believe it was January 23rd. We had announced this facility ahead of that council meeting, and Boyle Street had made itself available to council during that hearing and ultimately during that vote and that council decision. And I actually spoke directly to council and answered questions regarding this site in which health services were mentioned in that piece. And I think it's just important to raise that, you know, council was, when passing the bylaw as it stands right now, was aware of this facility and the potential for it to be there and that it fit under health services. That's it for me in terms of presentation and follow up on questions. I believe, let me just check my notes. Yeah, I'm available to take questions now.
Any questions for Mr. Tanti? Ms. Solis.
You mentioned a good neighbor commitment, I think was the word you used.
Yeah.
Is there actually a good neighbor agreement, or will there be an actual written agreement?
Yeah, so what we do have a good neighbor commitment. It's available on the website for the site. It's something that is stipulated that we have to provide as part of our regulations and part of our submission for the license. And so that is the formal document with which we'll need to adhere to. But it's not a formally signed document. It's a statement of commitments that we make.
Okay, I was going to follow up and ask if you worked with the community to develop this, but it's a commitment statement that you've published.
Yes, but informed based on the community consultations that we had. So those are the 2 public forums, the dozens of emails, telephone conversations, face-to-face conversations that we had, conversations with the business association, city council, and based on our experience in our other facilities as well.
Okay, thank you.
Mr. Jones.
I guess I'm a little confused on the consultation, because I understood from Mr. Walkowicz that if this permit was approved, then you would move into a consultation period or whatever with the federal government. You indicate it's provincial. So has that already taken place in your mind, or is that still to come?
So when you're talking about consultation, are you talking about consultation with the public or consultation with the public? So no, when we first proposed this site, in order to apply for the license, we had to go through an extensive community consultation process outlined by the provincial government. So that included 2 public events, one in December, the following one in February, as well as we created a website where people could email in questions, comments, concerns, as well as we put Cindy's phone number on the website, and I'm sure she loved me for that, but those are a number of the actions that we took in order to engage with the community.
Okay, because one of the appellants, I think, had mentioned yesterday that they weren't very satisfied with that process. And, but your indication is you had two sessions then?
Yes, I appreciate that there's various different opinions on the community consultation. What I would say is both those in-person consultations were very well attended. Over 200 individuals were at both of those events. As the individual noted yesterday, we brought city officials, provincial officials, EMS, EPS, and fire to those events. So they were able to be consulted, they were able to be questioned by community as well. And when the community wanted something different, we changed the format, and Cindy and I stood and took questions for 2.5 hours directly from those 200 residents related to this project. All of that was recorded and submitted as part of our community consultation. And like I said, we've been, consultation doesn't begin and end for us. Our intention is to be a good neighbor in the community, to work alongside community, to support community. We believe this is a net benefit for the community. And so those relationships need to be ongoing and continue, and we've committed to that as an organization. And I think the community liaison position, for example, was something that we heard from community was something that they wanted. They wanted someone that they could call, that they could talk to, that as issues emerged, they didn't want to deal with it at a quarterly meeting, they wanted to deal with it right away. And so we created that position. That position was created directly out of community consultation. As was, I would note, not just the security guard, but the rounds around the community that we've committed to. That was something that the community had asked for. Additionally, there's been issues, as was stated by Mr. Blythe, already in the community related to garbage and some behavioral things. So we've also, the garbage collection that's been mentioned was something that was requested, and needle debris pickup was something that was requested from community that we've done to alleviate some of those concerns and try and, again, be a net positive for the community.
Okay. The other thing was, I understood that initial approval was for 6 months and then annually after that?
Yes.
So what happens after the 6 months? Is there some additional consultation, or how do you determine whether you're meeting an objective or not by that 6 months?
So we'll have to provide data and stats related to the service itself. The province will also collect feedback from the community. We'll have to ensure that we're adhering to the good neighbor commitments that we set forward in that piece. What we submit to the government to make their decision, both at that 6 month period and every year after that, is dictated by those very strict regulations from the provincial government.
Okay, thank you.
Ms. LaPro?
Yeah, users of the site are members of the public as well. Has there been any consultation or engagement with them? If so, at what point in the process would engaging in that consultation take place?
Thank you. That's a really important question. Thank you for asking it. In the lead up to determining the site and determining that there was a need for services in this area, Cindy, and she referenced this, did some ethnographic research. We also operate, Boyle Street operates Higher Good, which is a social enterprise in the community that actually takes care of the bathrooms on Gateway Boulevard. They are frequently used by people in the community who are unhoused and are substance users. So we've collected information from them as well. And there's been ongoing conversations. We have a community and business liaison position that reports into my department, and has been going around to different businesses, but also speaking to unhoused folks in the community, talking to them about the site, what they'd like to see. So those consultations with service users started before, during, and will continue after.
Any further questions? Seeing none, we thank you for appearing before us today, Mr. Tanti.
Thank you very much.
And Mr. Walkowicz, you have a few other people on the list, but some have indicated they don't want to speak, so maybe we can go through them, unless you know of somebody else that will be presenting.
Yeah, I don't think so. I'll just, we'll go through just to double check, but I just wanted to, one quick comment just to clarify the whole sort of statutory, the multi-level statutory thing. The federal government sets out the exemption, this whole concept, which allows it to be non-criminal, has gone through. The powers of the minister in the Federal Act have been delegated to the province.
The province then operates this under the Mental Health Services Protection Act, and then they set all these requirements and they do the monitoring. And as Mr. Tanti put it out, they're actually more strict than others, with a 6-month and annual reviews and many requirements. So they're kept on the province administers that on behalf of the federal government. So it's federal, provincial, it's everything.
Thank you for that clarification.
Thanks.
So I'll just go through the list, and either you can speak on their behalf or they can speak if they're in the room. Ms. Heisler?
No, I think I'll speak on her behalf. Yeah.
Sure. Mr. Reininger?
I don't think he's making any submissions today, no.
Okay. Theo Admiral?
I don't think so either.
Doug Cook?
Don't think so.
And Ian Matheson?
I don't think so, no.
Then I think you're excused, Mr. Walkowicz. Thanks for appearing before us today.
Thank you very much. Oh, one thing before I go, I just wanted to mention, if the board does decide to proceed by way of condition, if that is the approach the board wishes to go, it might be helpful to have the condition sort of to be clear to say, must provide barrier-free access to the front door, which I think then would satisfy the compliance requirement from section 413 of the overlay.
Thank you. Okay, now we'll see if there's anybody else who wants to speak in favor of the proposed development. I do have one person on my list, Amber Haid. Maybe that was yesterday and not today. Okay, before we move to rebuttal then, is there anybody else here who wishes to speak in support of the development?
Can you unplug my computer? Is this one here?
Seeing nothing, then we will turn our minds to rebuttal, and we will go in the same order that we went with initially. So Ms. Agrias, will welcome you forward once again. And you know the drill, so no need to have any direction from me.
So just to start, and again, listening to the applicant's submissions, I said it at the outset and I said it again, I do wish to be clear, we are not here to debate the merits of safe consumption sites. That is outside this board's jurisdiction. We accept there is legislation that allows safe consumption sites. The issue before you is whether there should be a safe consumption site at this particular location. And so again, we're not here to argue about the drug epidemic, overdose deaths, or what should be done to address these very serious issues. This appeals about whether or not there should be a supervised consumption site at this particular location, on this street, in this DC1 zone. Now, I'm first going to respond to the argument regarding the use, but in the end, I'm actually going to tell you that the whole use argument probably doesn't matter, because the important part is the variance. And this matter actually, in my submission, ultimately will be decided by the variance. And I do wish to apologize. I took the board off on a tangent yesterday regarding the variance because I was looking at the previous version, and that is my error. But as you will hear, there is still an issue with this board's authority to grant a variance, and you just can't do it. Now, firstly, so why is the use important? Why is the variance important? So if we were looking at a development that was fully compliant with the DC1, then the applicant is entitled to their development permit, and there's no consideration of impacts. And in fact, that's what you heard from the development officer. That's what she did, is she said this is fully compliant, Class A permitted use, not looking at impacts. And to some extent, that's why you've got both the city and the applicant strenuously arguing that the use is art, that the use is a health services, and that there's no deeming involved. Because if they can convince you of that, then they don't need to talk about impacts, and nobody needs to consider the impacts. In other words, nobody needs to actually consider whether or not this site is suitable, and clearly it's not, given the intent of this DC district. Now, I want to be clear regarding the use, why I am talking about the deeming provision. And the reason why the deeming provision is important, and so this is section 7.1 sub 3 sub B, and it's on page 53 of my submissions. It's important because if the board or if the development authority has to resort to the deeming provision, then you treat the use as discretionary, and then you look at impacts. And so under that provision, under the deeming provision, if you have a use that doesn't squarely fit, so if this isn't squarely fitting in health services, even though health services might be the closest use, but if it doesn't squarely fit, you have to use the deeming provision, treat it as a discretionary use, look at impacts, look at the suitability of the use. Or the deeming provision comes up another way, and this is related to the extended medical treatment services. If you have a use that fits 2 or more use classes, again, you have to use the deeming provision, treat it as a discretionary use. So both the city and the applicant say, well, this is absolutely crystal clear, this is health services. And so you don't have to look at the deeming provisions. And the city referred you to the 2011 Supreme Court of Canada case in PHS. And of course, that case isn't in front of you, and it does make it difficult when the city shows up and argues case law that's not in their submissions and is not provided. And in any event, Mr. Gunther said, well, this case unequivocally decides the issue that a supervised consumption site is a medical treatment or that it's health services. And I disagree. It's not what the case said. It's a fairly complex decision. I'm going to do my best to explain it because it was mentioned, but again, it's difficult when it's being argued on the fly and you don't even have a copy of the case, and neither does anybody else. Now, most importantly, that case was not dealing with the definition of health services in the Edmonton zoning bylaw. So it doesn't help in interpreting the definitions. It doesn't help in interpreting the Edmonton zoning bylaw. And so this particular definition, the definition before us, does talk about health services. And I think Mr. Gunther focused on, well, there's a therapeutic aspect to it, and the applicant sort of says the same thing. There's a therapeutic or a counseling aspect. But let's be clear, in terms of the reality, what is actually happening is the primary use is not treatment and it's not therapy. These services are offered, and it's what I accept is sincerely being contemplated is going to happen, but that has not proven to be the reality. And we do have these statistics from the convention center and the statistics from the Commonwealth site. And what those statistics show is that the vast majority of people who are accessing supervised consumption sites, they don't access any treatment. So while treatment is available, and some are referred, and some may actually go on to a treatment program, when you look at the statistics at the Commonwealth Stadium site, 4 people transitioned to treatment. When you look at the convention center site, out of almost 9,000 people who went there, it was about 100 that were, it doesn't even say, it doesn't give you the numbers how many actually ended up in treatment. It was about 100 that were referred. So what we have is a use where, while there are other services provided, the vast majority of users of the facility are simply going there to consume illegal drugs. So the concept, it does sound good. People come in and they're helped, and that is true for some, and so there is a positive function because some people are helped. But for most, again, it's a place to go and consume illegal drugs. Now, I want to go back to the Supreme Court of Canada case. And so when you look at the activities at a safe injection site, and so on the face of it, you've got people who are engaging in what is otherwise an illegal activity. So they're in possession. They're purchasing and in possession of illegal drugs. And so in order to be allowed to do this, you need an exemption, as you've heard, from the federal health minister. Now, in the Supreme Court of Canada case, what happened is the minister revoked the exemption. And so what the court didn't say that allowing people to consume illegal drugs, that that's a health service. What that case was dealing with was people's charter rights. And so under Section 7 of the Charter, the right to life, liberty, and security of the person, and I'll give the paragraph references in case anybody wants to look it up, but paragraphs 91 and 92 and 93 of the decision. So what the court found was that by revoking the exemption, the Section 7 charter rights of individuals who are using illegal drugs, that their right to life and security of the person is being violated because they're being denied access to potential medical care, again, in the event of an adverse reaction. So in other words, the exemption is needed for these individuals to be able to access the medical care. And so there isn't anywhere in the decision where the court is equating consumption of illegal drugs with medical treatment or a health service. What it's saying is the exemption is needed in order to access the health service, and that violated a Section 7 right. The case actually raises a couple of other interesting points. I'll give the reference as paragraph 17, but it talks about the history. So paragraph 17 of the Supreme Court decision, there's a discussion about the history of supervised consumption sites in North America. And this particular site, which was in the Lower East Side in Vancouver, this was the first one in all of North America. And it opened in September 2003. And so what that supports is that at the time of the zoning bylaw, so at the time the health services definition was first adopted, predates 2003, this particular use, it didn't exist because there was no such thing as a legal supervised consumption site anywhere in North America. Wasn't legal, and so again, I suggest that points to where the deeming provisions come into play, because this was a use at the time the zoning bylaw was adopted, at the time the health services definition first came into place. This type of use didn't exist as a legal use. The other thing that the case, I think, highlights is, again, think about the use again. Now, I'm not arguing that a supervised consumption site, that what's happening there is illegal. But what I am arguing is that a supervised consumption site does involve the consumption of illegal drugs. There is no question about that. It's an illegal activity, and the only thing that allows it to happen is an exemption granted by the Federal Minister of Health. And yet the city and the applicant both say, well, it's obviously a health service. So something that's otherwise illegal but for a special exemption, and they're saying it's obviously a health service. And when you look at the definition of health service, again, that definition doesn't say that consumption of illegal drugs, again, made legal by, in a particular setting because of a special exemption from the federal health minister, doesn't say anything about that being a health service. And so again, it's my submission that at the very least, to call this use a health service, you must resort to the deeming provision. It doesn't fit, and it should be treated as a discretionary use. And, Mr. Walkwich tried to equate it with, people who don't like chiropractic services or people who don't like acupuncture. Those don't involve otherwise illegal activities. And so this is quite different. This is not, somebody doesn't believe in acupuncture. this is an illegal activity that requires a special exemption. And so whether or not we have legislation in place that provides for an exemption to make otherwise illegal acts legal, it actually really doesn't matter, because the bottom line is these activities are occurring. Again, buying and selling illegal drugs, using illegal drugs. And as I've indicated, not here to determine whether or not supervised consumption sites are a good idea or a bad idea in general. It's looking at the impacts at this site. So what are the impacts of allowing otherwise illegal activities, but for an exemption? So what are the impacts of allowing this type of activity on a street in a direct control zone that is intended for a pedestrian-oriented commercial shopping street? Now, the other way to get to the deeming provision is if something fits 2 or more use classes. And so that other use class, and it's being discussed, is extended medical treatment. And I agree, not a complete fit, because extended medical treatment does talk about room and board. But the city has used it with the George Spady Center. So we have the other Boyle Street location, where the city called supervised consumption site a health service, but we also have the George Spady Center, where the city classified a supervised consumption site as extended medical treatment. And what the city says is, well, okay, George Spady is different. And again, this is where the city, and I'll talk about this more, starts to enter a bit into the fray, but they say, well, no, George Spady is different because George Spady has an overnight detox. Well, the detox was there before. It's a separate pre-existing use, and I believe that Ms. Golick, in her submission, she actually does have the complete plans for what was submitted with the George Spady Center development permit. And I'll give you the page references and the plan numbers. So for the George Spady plans, if you look at, it's pages A10 and A12 in those plans, you can see what was there and what wasn't there. And so what you can see is the supervised consumption site is a totally separate component from the overnight detox, which kind of makes sense because, I mean, you're talking opposite ends of the spectrum. You're talking about one use where you are allowing people to use illegal drugs, and you're talking about a detox. So those are running at the same site, but those are 2 entirely separate uses. And what you can see on the plans is the supervised consumption site at the George Spady Center. And this is on, again, pages A10 and A12 of those plans, which are in Ms. Golick's submissions. There's no overnight component to the supervised consumption site. So yes, there is an overnight detox there, running as a separate use. There's a supervised consumption site with no overnight component, no room and board, and the city approved it as extended medical treatment services. And so what does that tell you? Well, that tells you that the city takes the view that supervised consumption sites can fit 2 or more use classes. And again, that brings you back to the deeming provisions, where you treat this as a discretionary use and look at the impacts. Now, there were some questions from the board about some of the impacts, and I do want to address them. And one of the questions was, well, there's some existing social disorder on White Avenue from the bars, and so how is this different from a supervised consumption site? And it's my submission that it's entirely different. So again, you've got some alcohol-related incidents that are happening from the bars on weekends. So you do have partiers at the bars on weekend nights. And there may be some overlap between the users of the supervised consumption site, but I'm going to suggest that these are 2 different issues. You know, you've got people who are over-consuming alcohol because they've gone to the bar on a weekend, versus people who are using illegal drugs such as meth and looking for a place where they can use their drugs. The other thing is when you look at the zoning, and so again, because of the zoning, again, businesses that locate on White Avenue, people that go to White Avenue, they know what to expect, right? It's a zone where there's bars and nightclubs. And so they expect those types of impacts. That's part of what goes with bars and nightclubs. And you contrast that with this particular direct control zone. Again, pedestrian-oriented commercial shopping street. So a business or owner on this street, they wouldn't expect to encounter a supervised consumption site and again, the associated impacts. You know, in this one, looking at the applicant's materials, 14 hours a day, 7 days a week. It's not just weekend nights. Every single day of the week for most of the day. And so not even close to the impacts that are being seen on White Avenue associated with the bars. There was also a question from the board, well, what conditions could make a supervised consumption site work here? And I think the point is it doesn't work with any conditions. And of course, the zoning bylaw, when you go through it, it acknowledges that some uses simply just don't work in certain sites. So we have some uses that just aren't allowed in certain zones. You know, you can't put a factory into a residential district because no matter what conditions you put on it, it won't fit. Sometimes you have separation distances from incompatible uses, you know, cannabis stores and schools. But in certain locations, you just can't have a cannabis store, period, because it doesn't work, it doesn't fit. And that's the case here. A supervised consumption site on this particular street in this zone doesn't work. The impacts can't be mitigated. Impacts like needing security for de-escalation. You know, looking at the supervised consumption site standards, and those start at page 171 of my materials. So 173 talks about the designated search area. So this is the area that, again, the facility has to indicate where they're going to look for, again, needles and other drug paraphernalia being illegally disposed of. Okay, that's not an impact that you would expect in this particular zone. There's the reference to the safety plan. And again, the safety plan is to deal with incidents arising from users of the facility, not an impact that someone would expect on the street. And so these requirements for supervised consumption sites, they're an acknowledgement of the impacts. They're inherent in supervised consumption sites, and they can't be mitigated by conditions. Think about this specific site, and again, in terms of if you're trying to think about, well, what conditions could you possibly put on it to make it acceptable? Well, the configuration of the site itself creates a problem. As you heard, there needs to be an area where people can congregate. And it's not possible on this site because there's no space. It's built right to the property line, so the only place to congregate is on the sidewalk or in front of neighboring businesses. Sometimes when you have to start looking at putting a number of conditions on a use to make it fit, that actually tells you that it doesn't fit. So if you're looking at saying, well, we have to put a number of conditions and maybe we can make it fit, and the more conditions, at some point you say that this is my sign, it doesn't fit. There was a question from the board about lineups. And what we heard from the applicant is they don't anticipate an issue with lineups. But then we also hear about how needed this use is and how there's a drug epidemic, people overdosing, and there's a potential for the site to be well used. And so, again, it seems inconsistent. On the one hand, we hear about the need and how many people need this, and on the other hand, we hear, well, but we don't think there'll be any lineups to get in. The building is small. And if you look at the plan, so is the waiting area. You know, and it's not a stretch to say that there'll be lineups. All anybody has to do actually is even drive by a Medi Center. And they have lineups for people wanting to get in and use them. We also heard from one of the Boyle Street representatives about some of the learnings from their other locations, and she specifically referenced the Commonwealth site. And she gave you some anecdotal evidence saying basically it wasn't a problem. Well, I'm going to give you anecdotal evidence that says otherwise, because during that time frame, I was quite involved with an organization that had its offices at Commonwealth Stadium. And I can tell you what happened. Again, this is anecdotal, but it's responding to the anecdotal evidence that was provided. But I can tell you from firsthand experience and from what I was hearing from the employees of the organization, there was an increase in break-ins in their cars. People were told, employees were told, do not leave anything valuable in your cars. There were increases in the employees being approached for money as they were going to their cars in the parking lot. There were increases in employees being put in uncomfortable situations, being followed to their cars, being approached, some of the female employees, again, having remarks made to them, to the point where that organization implemented a policy that if anybody was leaving, this is during the day, if anybody had to go to their vehicle, somebody had to accompany them. So again, we hear about how, again, the safe consumption sites, do they help people? Absolutely. Are they providing a needed service? It sounds like it. But what about the impacts, again, on businesses, organizations? And again, the Commonwealth one is an excellent example where there was a significant negative impact, again, on the environment for those employees. The applicant also talked about, well, there's a misconception about the condition of people who leave the facility. Now, again, that's coming from someone who's familiar with the facility, who's educated. And I'm going to say most people don't have that level of education or knowledge about supervised consumption site. Most people, and again, it may be out of ignorance, and I'd probably count myself among them, I'd be fearful to be around people who are on meth. And I think most people would feel the same way. And again, that may be an uneducated viewpoint, but it's the perception that's important, especially when you're talking about a commercial shopping street. Again, people aren't going to want to rent buildings on a street where there will be users of illegal drugs. Customers won't want to frequent those establishments. And so when they're trying to figure out, well, where do I want to go for coffee? They're not going to read the literature and all of the materials that have been provided here to say, well, you know what, actually, when people leave the supervised consumption site, we check them and they're all fine. Except for they might not be, because otherwise you wouldn't have the need for the de-escalation. But again, people aren't going to read that. It's going to be the perception. And that's the reality of what these businesses and what these property owners are living with, is the perception. And again, it's a pedestrian-oriented commercial shopping street. And so what we have with this block, it's a success story. So the DC one has a vision, and it looks like it's working. So you put this development in the middle of it, and what does it do to the vision? And you have to ask yourself, so what's the point of an ARP? What's the point of an overlay? And what's the point of doing a DC that's designed to achieve certain goals and then approve a development that is totally contrary to those goals? Now I'm going to talk about the variance. We have the city and the applicant, everyone agrees this development needs a variance, and it was missed. Now, I do have a short comment on the scope of the variance. I'm going to talk more about whether you can grant the variance, but I have a short comment on this, on the scope of the variance. And that's the issue of also, if you're looking at a variance, what do you consider? Do you consider the impact of the development or just the impact of the variance? And Mr. Walkowicz discussed the library cases, and There are some comments, again, not really clear direction from that case about what are you looking at. My submission is first, well, look at the wording of the provision. It says you consider the impact of the development, not the impact of the variance. I'd also point out there is a fairly clear direction in the Thomas case. And just so you have the site, and again, I think it's one probably that this board is quite familiar with because it comes up a lot. It's 2016 ABCA 57. I'm going to read to you from paragraph 33, and this is from the then Chief Justice, and this is what she had to say. A subdivision and development appeal board is required to consider whether the, and she's got this in italics, proposed development, notwithstanding its noncompliance with the land use bylaw, materially interferes with the amenities of the neighborhood, or materially interferes with or affects the use, enjoyment, or value of neighboring parcels of land. So that passage says you're looking at the impacts of the proposed development, and that's pretty clear. So if there is jurisdiction to grant a variance, and everyone acknowledges there is a variance, it's my submission that you are looking at the impacts of the development. And so again, we're back to looking at impacts. But here's the bigger point. So again, we've got both the city and the applicant saying, okay, yeah, there's a variance and it was missed. And everyone just kind of glosses over that by saying, okay, well, either impose a compliance condition or just grant a variance. It's my submission that the board needs to really closely look at both options. Firstly, none of this, although the development officer maybe could have done some of this, none of this is what she did, because she just treated it as a Class A permitted use. And for this board, both options are outside of your authority. And, you know, my expectation was, and maybe this was wishful thinking, was that the city would just come here and acknowledge the error and said, we made an error. If there's a solution to the error, whatever that solution is, the plans need to be circulated. But instead, the city came here, and while they tried to defend the error, and then try to come up with solutions, and I'd submit that's just not the city's role. The applicant can argue about solutions, but it's not what the city should be doing. And, you know, just a side note on a process issue, I was thinking about this yesterday, about how sort of the hearings run. If the development officer's role really is to come here and just explain the decision, then actually the development officer should just present first. And that's the way it's done, as far as I know. Any other board I've been in front of in this province, where the development authority is coming to explain, they go first. What we have here, because of the order of presentation, is the development authority ends up responding to the appellant's arguments. And so they end up engaging on the merits, and they end up making arguments that actually aren't part of their decision. So in other words, they come up with new reasons for why they granted the approval or new solutions, and that's not their role. And so it occurs to me that it's the order of presentation, I think, that lends itself to this approach. And so instead of simply coming here and explaining why they decided the way they decided, they end up responding to the appeal. Anyways, going back to the offered solutions. And so the first offered solution was, well, just impose a compliance condition. And so that's the requirement of the condition. I think they were saying, well, you can just impose a condition, require a universally accessible principal entrance. And the city even went so far as to suggest, well, we could just have a creative solution. Well, don't we all need to know what the creative solution is? Doesn't there need to be a plan? And so what the city says, well, you know, it's just good enough, put a condition saying make this development comply. Don't need to see the plans, don't need to circulate the plans, just impose that condition. And so I guess that makes you wonder, why bother even submitting any plans? Just issue a development permit and say, make it comply, and we'll worry about how that's done later. Problem is with that type of condition, because it's not being properly circulated, whatever change, whether you're lowering the building height or putting in a ramp or maybe moving the entrance somewhere else, what you don't know without a circulation and without a plan is whether or not that creates some other non-compliance. And so it's quite astonishing for the city to say, well, we'll just have a creative solution to ensure compliance, and we'll just go along with whatever creative solution the applicants come up with, and we won't worry about whether or not there is some other non-compliance. But again, it's my submission, the creative solution needs a plan, and whatever that creative solution is, it's going to involve a significant change. You're either going to have a ramp, you're going to change entrances, you're going to be changing the height of the building. Something is going to have to change. And these types of changes have to be reviewed for compliance. You have to determine, does the creative solution to address this variance, whether or not it's going to cause some other issue. And the only way you do that is a plan, a full review, and a full circulation. It's not something that this board can just sort of do on the fly during the course of a hearing. Now, in this case, we have the applicant actually has provided their solution or their preferred solution, and they say, well, we'll do a ramp on city property. So totally outside the property line, we're going to put a ramp. And there, you heard Mr. Johnson's submissions, and I think he's got a written submission. I'm just going to pull that out so I can refer to it. And so in Mr. Johnson's submission, he does acknowledge that, again, universal accessibility is a fundamental condition of good design. It's also a provision in the overlay. And they acknowledge that the barrier-free design guide, which again, I acknowledge, it's a building permit, or it's a building permit issue, but it's now being imported into the zoning bylaw. So now it is something that the development officer and this board does have to address because it's in the zoning bylaw. So they acknowledge we're looking at the barrier-free design guide, and the indication is from the applicant, Mr. Johnson, is the applicant's going to comply by providing a ramp in accordance with the barrier-free design guidelines. Well, if you look at what they have designed in their plans, and this is without the benefit of a plan review. But you can see, again, it does create non-compliances. The first is it does create a deficient sidewalk width. It does not comply, it will not comply with the City Complete Streets design standards. It's too narrow. And the city never even addressed this. Again, when they were talking about the creative solutions, they never addressed that one of those creative solutions results in a non-compliant sidewalk. The other thing is the top landing, again, of what's being designed. According to the barrier-free design guidelines, it must be 1,500 millimeters by 1,500 millimeters, which actually is about 5 feet by 5 feet. And this one, according to the plans, is going to be 4 feet, 5 3/4 inches wide. And those references come from the Barrier-Free Design Guide, pages 26 and 34. And again, the city just ignores this, doesn't exist. They don't talk about what's being put forward as a solution is not compliant. And again, that's why it's important to have a proper circulation. So we shouldn't even be attempting to do this type of review here. There should be new plans submitted, reviewed, by the Development Authority and by whatever other appropriate departments have to review it through the circulation. So for a new plan, there needs to be a new application. And again, that's consistent with the practice of this board. It's consistent with the decision that I provided to you. So second option is the variance. And as you heard from the city treated this as a Class A permitted use, and so they say that, again, when issuing the development permit, the development officer did not consider impacts. Now they acknowledge that a variance was required, and so somebody should have been applying and assessing, so the development officer should have assessed those impacts. Now, when I look at the development officer's report, it's in your materials, and I go to the very last paragraph. So again, they say when issuing the development permit, we didn't look at impacts. Then I look at the development officer's report and says, the last paragraph, it is the opinion of the development officer that the proposed Strathcona Health Hub does not unduly interfere with the amenities of the neighborhood nor affect the use, enjoyment, or value of neighboring properties. That doesn't belong in her report. She's here to explain the decision that she made, not to come up with new arguments. And the decision, and what you heard from her and from Mr. Gunther, is the development officer never assessed the impacts. And so that comment about impacts has no place in her report. Development officer is supposed to explain her decision, not come up with new arguments. Now let's look at the variance authority. And I looked at it carefully, and I looked at the current section, and again, I apologize for referencing the old section. That was my error. Based on Garneau, because this is a direct control district, your authority is the same as the development officer. So as Mr. Walkowicz said, and I think all of the lawyers here agree, you're not looking at your variance authority under section 687 3D. You're looking at what the development officer can and can't do. So one of the things, section 11.4 sub 1 sub B, so these are the limitations on a variance. So one of the things a development officer can't do, can't vary height, and neither can you. The effect of this variance, again, if there is a variance to be granted, would be to vary the height of the rise to the principal entrance. And in my materials, you'll see in the barrier-free design guide, page 200 and page 212, again, the maximum change in level without a ramp is 13 millimeters. And the rise here is well in excess of 13 millimeters. So my first submission on your authority is in order to grant the variance, you effectively have to vary the height of the rise to the principal entrance, and you can't do that. The better argument, though, and this is the important one, and this is the one that I submit decides this whole appeal, and it goes back to the Main Streets overlay. And so if you go to page 79 in my submissions, and you'll see section 15, or it's actually 819.4 sub 15. And remember, you can only do what the development authority can do. There's the requirements for a variance. So if there's going to be a variance granted from the overlay, there are certain things that the development authority shall do. Firstly, the Development Authority shall send notice to the municipal address and assessed owners of land within a distance of 60 meters of the site, the president of each affected community league and each business improvement area association, and solicit comments directly related to the proposed variance. Second, the development officer shall not render a decision until 21 days after the notice has been mailed unless development officer has received feedback from all specified recipients. And thirdly, development officer shall consider comments. And again, it's related to the variance. This wasn't done. And in fact, if you go over to page 228 in my materials, and so this is again the development officer's, again, her assessment, where she goes through each of the applicable regulations, and you can see on page 228, and there's the two columns, and on the right-hand side, 819.4.15, DP application complies with MSO, not applicable. The community consultation requirement cannot be waived, and it cannot be varied. And it can't be replaced by some other consultation. So it can't be replaced by some consultation with the minister or with the province. It's a requirement that the development officer take certain steps. Send the notice out, solicit comments on the variance, and send it to certain people. This has been confirmed again in the Thomas case from this Court of Appeal. And I'll give the citation again, 2016 ABCA 57, paragraphs 36 and 37 from the then Chief Justice. And what she said was, allowing the SDAB, and by extension, a development officer to waive community consultation requirements would effectively render, now 814, that's dealing with the mature neighborhood overlay, so it's a different overlay, but similar consultation requirements, would effectively render section 814.3 sub 24 meaningless. A community consultation would always be liable to being waived, since the various test under section 687.3D is not directed to non-compliance with material procedural requirements. Under this test, non-compliance with a community consultation would never in itself unduly interfere with the amenities of the neighborhood or materially interfere with or affect the use, enjoyment, and value of neighboring parcels of land. This being so, at no time would there ever be a valid reason not to waive community consultation requirement. Such a result would be untenable. An interpretation of the legislative scheme that would effectively abolish the community consultation requirement in the zoning bylaw must be rejected. The disputed words themselves and the context in which they are used reflect the legislative intention that the SDAB's variance power under 687.3D be restricted to varying development standards, not a material procedural requirement such as the mandated community consultation. Now, I agree, Thomas was looking at 687.3D, whether or not you could vary something other than a development standard. We're looking at a variance power under 11.3, but if you compare the wording of section 687.3D and 11.3, it's exactly the same. So it's the same reasoning. A variance can be granted to a development standard, so you can vary a side yard or a setback of some sort, you know, there's a number of those development standards. But what you can't vary is a community consultation requirement. And it's community consultation specific to the variance. And again, as we've seen, the development officer in her own notes confirms she didn't do that. So the bottom line is, you know, and again, the city and the applicant, they just ignore this requirement and kind of gloss over it. They also ignore the Thomas decision. So the bottom line is, a variance can't be granted here. because there's a mandatory community consultation requirement in section 819.4 sub 15 hasn't been met, and it can't be waived. I'd also point out that arguably with a ramp on city property, so again with this compliance condition or the creative solutions, you run into the same issue. Because a development that encroaches outside the property line, that for sure is not fully compliant. So that for sure is not complying with the requirements of the bylaw. And so that again needs a community consultation, which again, with a new application, if they want to come in and make the new development permit application, either with the variance or with a ramp, then that process will take place, and there will be that community consultation specific to those non-compliant items. But again, that's not being done. Your authority is the same as the development officer's authority, so you can't approve without complying with that mandatory requirement. Now, the last thing that I just wanted to touch on, and there were comments, it actually stuck out mostly from Mr. Gunther, where he admonished some of the appellants and others too, to a lesser extent, for how they characterize the users of this facility. And there is no question that everybody has a concern about helping people who need help. And the city absolutely has a concern or a desire to assist people who need help. That's all understandable. What's happened in this case, though, is that that desire to assist people who need help, what's being forgotten is the impacts, and I think one of the other presenters, one of the other appellants referred to it as the people with skin in the game. The people with skin in the game have been forgotten. So these are the people who live there, who've invested in property there, who've invested in businesses there. And it seems that while the city does have appropriate concern for users of the facility, people who need help, they don't seem to have the same level of concern with the people with skin in the game. And so again, what we're asking is that this board take their interests into account and consider the impacts on them and deny this development. And so unless there's questions, that was all I had by way of rebuttal.
Any questions for Ms. Agrias? I imagine some. Let's start with Ms. Solis.
Thank you. I'm going to start with something you said very recently first before I go back to an earlier point. You've indicated that we can't vary the height of this development. As my understanding, or perhaps we need to clarify or confer, I don't think that it refers to the height of a step. I think it refers to the height as in capital H, height of the building.
No, look at the definition of height. And I should have brought it with me, but check the definition of the height, because I did check that too. It used to say that, and it used to be that. And again, now that I'm acutely aware of making sure I'm looking at the most current version of the zoning bylaw, it does not say that anymore. Height is just now the vertical distance between 2 points, capital H height.
That is the definition.
Yeah.
Okay, thanks.
So height can apply, in my submission, to more than just the height of the building. As I say, it used to be the measurement from grade to the midpoint or whatever. That's the old height definition. The new height definition, it's my submission, could apply to anything that involves the measurement of a vertical distance between 2 points. And so what we're talking about is effectively varying the height of the rise to the front entrance.
Okay, well, thank you for that, your view on that. And the other is that earlier in your rebuttal, you indicated that you were making the case about it not being a health service or not fitting clearly in the definition of health service, and you referred to the federal legislation. And if I recall, if I wrote down if what I wrote in my notes is correct, I've got it circulated, circled here somewhere, that in that federal legislation allows the exemption for medical purpose. So you're saying that this isn't an exemption for medical purpose?
No, I'm acknowledging that there is an exemption that is being granted. What I'm saying is, though, the activity is otherwise illegal. So what, whether it's legal or illegal, we're looking at the impacts of the activity. And so we're taking an activity that is otherwise illegal. I don't think there's any dispute on that. But for a special exemption, it would not otherwise be allowed. Now, the section, I've got the wording of section 56. Because again, I think there was some conflating of some of the wording that was being used, but it does say, so it doesn't say medical service. And I'm going to read to you section 56 of the CDSA, I think it's Controlled Drugs and Substances Act, or let me just see if I can find what that's defined as. But anyways, it's section 56 is the exemption, and the wording is the minister may, on such terms and conditions as the minister deems necessary, exempt any person or class of person or any controlled substance or precursor or any class thereof from the application of any or all provisions of the act or regulations if, in the opinion of the minister, the exemption is necessary, it says, for a medical or scientific purpose.
Yeah, that's what I was quoting, medical
Okay, right.
purpose.
Okay, but it's not saying that there's a medical service being offered. Again, you look at the wording, it says medical or scientific purpose. So again, the granting of the exemption, in my submission, does not determine the issue of whether the definition of health service in the Edmonton zoning bylaw is met. There may be a medical purpose, and in fact, what this case found the medical purpose was, it didn't really actually focus so much on that. What it focused on was the treatment that is offered to individuals who have an adverse reaction. And so it's saying, okay, yes, there is a deprivation of their right to life or security of the person, because if we don't make this illegal act legal in this setting, they can't access a medical service. That's somebody who's there to give them treatment if they have an adverse reaction. But it doesn't go to the definition of health service in our zoning bylaw. And again, it also, let's look at the evidence that's in front of you in terms of the actual statistics, in terms of what's happening here. Consumption of illegal drugs is the vast majority of people who access the facility. That's what they do. And so my submission is, yeah, you might decide that health service is the closest. And you might say, well, that's the closest use. Fine. Doesn't fit squarely. It's not obvious, like a doctor's office or a dentist's office. And so you have to go to the deeming provision. And then, of course, there's a secondary argument on the deeming provision, and that is that the city itself has classified supervised consumption site as two different use classes. That also takes you to the deeming provision.
Okay, thank you for that.
Mr. Pearl.
Thank you. This is a good segue. The deeming provision. We've heard your submissions that some of these other sites were classified as a health service. The George Spady was classified as the extended health use. To your knowledge, was the deeming provision used in any of those applications? No.
No
so
idea.
In those situations, it would have been determined to be solely one or the other?
I don't know, because those were never subject to appeal, and so you never got to see a report from the development authority saying that there was a deeming. I don't know.
Okay. Thank you.
Mr. Carbo?
Yeah, just a clarification. You said that either the options of variance or condition are really not under the board's authority. Is that what you were telling us? That in the case of that there would need to be a new application for a ramp if we were going to go with the condition that there be a ramp. Are you saying that the board can decide that this needs to go back to reapplication?
No, what you do is you just simply refuse.
You're just saying this is denial?
You just refuse, and then implicit in that is that the remedy is you make a new application.
Okay. I guess that's kind of where I was going with that. And in the other case, a variance can't be granted because the consultation didn't take place appropriately. Am I clear on that?
It didn't take place at all.
Okay.
The required consultation in accordance with the bylaw did not occur. How do we know that? Well, we can look at the development officer's own assessment, and she confirms she did not comply with that provision because she didn't think it applied because she missed the variance.
Okay. And that would stop it right there then, you're saying?
That would stop it right there because this board, again, is bound to follow the directions set out in the land use bylaw, or the zoning bylaw, and that's a mandatory direction in the zoning bylaw, and it can't be varied or waived.
Okay, thanks for the clarifications.
Okay, Ms. Agrias, I have a couple questions. One's in relation to this height argument. The regulation, as I read it, states that that entrance just must be accessible. It doesn't prescribe necessarily a height difference, and accessibility can be achieved through many ways. So I guess I'm wondering, is there really a variance to height being granted here? Because it doesn't contemplate really a difference in height between 2 points. All it states is it must be accessible. The variance is not we're varying height, it's we're varying the need for that elevation change that would...
No, and I agree with you, and that's why I indicated, I think it's the effect. You're right, it's not a direct height variance because the bylaw itself does not specify a measurement. You have to go to another document to get the measurement for the universal accessibility. But the effect of the variance, because what you'd be saying is we're granting the variance and we're going to approve this as is. The effect of the variance is to allow the rise to the front step to be in excess of what would be the maximum height. So again, not a direct, but that's effectively what you'd be doing is varying height.
Okay, I think I follow. Sorry, I'm just trying to collect my thoughts because there's some new stuff here that I haven't considered. So, does anything turn? Thomas was written at a time where the community consultation obligation was on the applicant. Here, and it's been changed subsequently in the MNO and the MSO. It's now an obligation of the development authority. Does anything turn on that?
I don't think so. Because again, what the underlying point from Thomas is the variance power only goes to a development standard, not to a community consultation requirement. There doesn't seem to be anything in the reasoning in Thomas that distinguishes between who's doing the community consultation. It's simply saying if there's a community consultation requirement, it can't be waived. You can only waive or vary a development standard. And clearly that's not what a community consultation is. It's a procedural requirement.
Okay. I don't have any other questions, but I assume that somebody in the back is going to stand up asking for a chance to respond to this.
Yes, so there were a couple of things raised newly. The Main Street overlay consultation issue raised. I do have a comment on that, and I have a comment on the height aspect as well.
Okay, so Ms. Agrias, I think we can agree that there is some new information that the respondent should be given an opportunity to respond to.
Yes, that's fine.
Okay, what we'll do then is we're going to break for lunch because I think if I need to wrap my head around this, some other people might need to wrap their heads around it as well. We'll return at 1:15. We'll go back to Mr. Walkowicz to respond. Mr. Gunther, are you looking to respond as well, based off of Ms. Agrias' comments on rebuttal as well?
Depending on the ground Mr. Walkowicz covers, the development officer and myself may have some
Ms. Agres, do you take any issue with Mr. Gunther responding? You've indicated that their role here should be just to present their decision-making. I don't know what he's going to say either. So.
Yeah, as I say, it depends on what he says. I can't imagine anything that he would say that would be clarification, but maybe it will be. But,
Okay.
you know,
Well, we might have to see where we end up when the time comes for Mr. Gunther to respond. And then if you object, we'll have to put that on the record to any submissions that you do object to and the reasons for that. So what we'll do is when we come back at 1:15, Mr. Walkowicz will have a chance to respond. And then Mr. Gunther, at your option, you may have a chance to respond. And then we will return to rebuttal and give you an opportunity to respond to the responses. And then we'll go through the remaining
okay. I was just going to mention the other appellants, I think, may have a rebuttal as well.
Rather than
Yeah.
go through rebuttal for everyone and then go and let Mr. Walkowicz and the city respond, we'll let them respond, and then the remaining appellants can respond in totality to everything they've heard. Does that work for everyone? You're making me earn my lunch today. So thank you, everyone. We'll see you all at 1:15. Okay, welcome back, everyone. Mr. Walkowicz, we'll invite you forward at this time to respond to Ms. Agrias's rebuttal.
And thanks for giving me this opportunity to comment on the issues that arose in the rebuttal with respect to the ability to deal with a condition or in the alternative, a variance. The first thing I want to do is really look a little bit maybe more detailed at the development regulation we're talking about and what it actually says and what it doesn't say. So the regulation at issue is in the Main Street Overlay 819.4.13, where a commercial use is provided at ground level abutting a public roadway other than a lane, the principal entrance shall be designed for universal accessibility. Now, as I said earlier, universal accessibility is not a defined term. It's a generalized term. Nowhere is it defined what universal accessibility is, which means it just has its common meaning. One thing that this thing does not do is incorporate by reference any other document. It does not incorporate by reference the Alberta government's barrier-free design guide. Note, it doesn't even use the same word. The words that they use are barrier-free paths of travel, which is part of the building code. It doesn't say that. It doesn't say you must comply with the barrier-free design guide of the Alberta government. It doesn't. It just says undefined, designed for universal accessibility. We've acknowledged that there's a problem there because I think from a factual basis, if you have a step that's so many inches that you can't roll a wheelchair over, you're not providing universal accessibility. So that's acknowledged that we have to deal with this step. But we don't have to deal with this step, particularly for the development law purposes, in any specific manner other than in a general manner. And this is why it absolutely can be dealt with by condition. When can you put conditions on a permit, particularly one like this, where there's a listed use, as we submit, we're well within the exact corners of the listed use, and there may be an issue as to whether this is complied with. You can actually put a compliance condition, because you know you can put conditions, as we just, this board just did in the King Thunderbird Center matter, when you're using conditions to confirm compliance. There's an issue with universal accessibility granted. It doesn't say how it has to be granted, whether it could be by elevator, by a ramp, by an internal ramp, by removing that step, by cutting out the cement. There's numerous ways that it could be done. And this board absolutely could put a condition on it that simply says, must comply with, you must provide universal accessibility to the principal entrance, to mirror the exact words. At that time, there's no variance needed, and the whole issue of the variance doesn't even arise, because you're not varying any part of the land use bylaw. You're simply compelling its compliance. Something was missed, and you can do it. This is not a situation where you have using condition to basically create a whole development. It was sort of implied, well, you would need to have plans, you would need to have this circulated. They could cause other aspects of nonconformity. Two issues with that. This is not having a condition where you're doing what I would say is the inappropriate condition, where you say, it's a condition that you comply with the land use bylaw and you don't do any type of review. That's not the case. We have one issue. It's compliant in all respects. One issue. We have to, the principal entrance shall be designed for universal accessibility. It's acknowledged that step doesn't provide front principal entrance universal accessibility. All that has to be done is dealt with. That is easily something that can be dealt with by condition. It's a condition that ensures compliance with the one issue that we have. At that time, there are no variances because no aspect of the zoning bylaw is relaxed. The other aspect is, if somehow that was done in an inappropriate manner, even though it's relatively small, it's an enforcement issue. The permit is the permit. We have a permit to build this structure. One thing was missing from the permit is that it didn't have the design for universal accessibility, and that can be put in by condition. So this board absolutely has the ability to do it by condition, and it's an enforcement issue if that's done in an inappropriate manner. Universal accessibility is not defined. It can be done in many ways, quite frankly, which would then, to the satisfaction of the enforcement officers, to ensure that universal access to this place has been provided. And again, there would be more than one way to do that. So a condition is appropriate. And again, before I leave that point, again, what's been submitted as the part of the building code, or to be precise, the Design for Independence and Dignity for Everyone, the Barrier-Free Design Guide from 2017, that's where it has that 13 millimeter provision in there. It's not incorporated by reference. When another document is incorporated into legislation by reference, it has to be specifically named. This is one way in which the undefined term universal accessibility could be granted. Obviously, if you did this, you'd be fine. But it's not incorporated by reference. This 13 millimeters is not a development requirement. I want to talk briefly, very briefly, about now whether or not the variance issue. But again, like I said, if you grant the condition, or if you just not grant, if you impose a condition to require compliance with this section, then there is no issue of the variance. We don't even have to go there. Nothing's being varied, nothing's being relaxed. Every single provision is being enforced. I would submit that you do have the jurisdiction to grant the variance, and there are two reasons for that. First, the first argument raised in rebuttal was that this would be a height variance. And as we know, you cannot, the development officer's variance power, which we're dealing with here today, has in section 11.4, it says, B, it says, except as otherwise provided in this bylaw, there shall be no variance from a maximum height, maximum floor area ratio, or maximum density regulations. So no variance from a maximum height regulation. This isn't a maximum height regulation. Not at all. This is a regulation to provide universal access. It could be varied. So I think that's enough to do with that. The more involved analysis deals on the variance front deals with the provision in the Main Street overlay, which has in section 15, I believe, of that same section of the overlay, 819.4 sub 15 states that when DO under this overlay is giving a variance, there is a notification requirement and a, let me just look here, exactly what it says. And to solicit comments, so a consultation process. But we aren't dealing with a normal application that has a normal zone that's covered by the overlay. If you look at the overlay, what is it applied to? Without anything more, it applies to a site zone CNC, CSB, CB1, CB2, CHY, CO, and CB3 located within a map. We have in the DC bylaw, in 4.1, we have the inclusion of certain provisions of the overlay into this DC bylaw, which is of course what we're dealing with. And the DC bylaw provision that includes it is section 1, and that's the same section that has the variance power. Note the variance power here is only references section 11. It does not reference section 815.415, which has that consultation provision. Section 11 has no consultation provision in it. So when we look at it, we already have seen that the DC bylaw has two types of variance powers. We had the variance power in section 12 of the DC bylaw, which requires consultation with the heritage officer. We had already acknowledged that, well, if we were doing a variance for something other than section 1, we would have to have that consultation. But we're not, because Section 1 itself has its own variance power in it. And that variance power says you can exercise your normal variance powers in accordance with Section 11. Doesn't say, and also in accordance with 819.4 sub 15. It's just the normal powers under Section 11. The normal powers under Section 11 don't have a variance, don't have a consultation requirement. So I would submit that that was explicit authority by City Council in this DC bylaw, that when dealing with modifications, any modifications of Section 340 or 819, you simply use the process in Section 11, and Section 11 does not have a consultation requirement. So that would be my submissions on the things that are new, and I'll keep them just to that, because I know the rebuttal to rebuttal should only be limited to something newly raised. And my final sort of point on this is that the issue of the variance, and all these issues of the variance, whether the height or the consultation requirement, do not arise if this board simply mandates compliance with the bylaw by condition.
Thank you, Mr. Walkwich. I'll see if there's any questions arising from your rebuttal to a rebuttal. I have a couple. So the DC clearly brings in all of 819 when it references the MSO. How can we say then that the requirement for consultation isn't brought in? It doesn't say that the MSO is brought in less 819.415.
I would agree that if you read 1 by itself, just the front part of 1, it would bring it in. And in fact, if you just had that, I think you would still have a variance power, because 819 contains a variance power in of itself. This is the same as, quite frankly, in the Garneau case, where the variance power wasn't included in there. It was whatever variance power was in the document that was incorporated. So 819 has a variance power. I'm not relying on that variance power, because that variance power hasn't been met because there wasn't a consultation. So 819 has a built-in variance power. 1A wouldn't be necessary to deal with 819 because it has its own, it's built in. That's where it says, so that's why I'm saying I would agree with that statement, except I think it's been accepted out. While it has 1, then A, if you want to vary it, follow Section 11. And Section 11 doesn't have that.
Sure, but Section 11 still requires consultation. Like Thomas says we can't dispense or vary with that requirement. And even if you're using the standard variance power in Section 11 of the bylaw, you still can't dispense with the requirement for consultation, and you still can't waive the requirement for consultation. Even though it's not contained in Section 11, it's still a requirement. It's a procedural requirement that, from my understanding of Thomas, needs to be complied with.
Well, in
even
Thomas,
using that normal variance power under Section 11.
The way I see it is that Section 819 contains its own variance power. I think Section 11 wouldn't even have to be there. If Section 11 wasn't there, then the DO couldn't vary almost anything, but they could still vary the Main Street overlay, because the one that has the consultation process has a built-in premise. Anyway, my submission is that for 1A, by not referencing again this variance requirement, this consultation, only 11, and 11 doesn't have baked into it any consultation, that you wouldn't need to access that consultation, because I don't need the variance power in 819.4 sub 15. I don't have to use that. I'm using a different one. I'm using the one in the direct control bylaw. I guess what I'm saying is that, yes, I agree with you that if you didn't have a direct control bylaw and you were just dealing with a normal case, then yes, I would agree with you that the normal variance power would have to include that. What I'm saying is this DC bylaw has a very specific thing that says if you're going to vary the Main Street overlay, you have to follow Section 11, just Section 11, and that doesn't have a consultation requirement.
I understand that point, but the way I read it is you don't even get to 11 unless you've applied the whole MSO first. So if you apply the whole MSO, it states that when a development permit application doesn't comply, then you must consult prior to even making your decision on whether or not to grant the variance. It's a precondition to making that decision. Is that not how it works? Is Thomas not written to say you can't even go there until you've consulted?
Well, of course, Thomas was talking about a different, it was in
Sure.
a different provision, not this exact provision. And I would, again, my position is just that this DC bylaw is short-circuiting that it was an express intention of council in 4.1A to say, DO, you can vary this, follow section 11.
Okay.
So that would be a submission on that. And my general point, though, of course, is for the condition, none of that, this needs to be done with, because then there's no variance. No variance is being granted at all, and that then you have a DC permit for a listed use, no variances, because there is no variance if a condition is applied.
Okay, so if we take this outside, just for argument's sake, outside of the context of a DC, this was a CB2 in an MSO zone.
Yes.
We required, an application was received by the city. It was determined that it did not comply with the principal entrance accessibility regulation. Then at that point, the city has an obligation to consult with the neighbors prior to rendering a decision. Is that correct?
Prior to granting a variance.
Okay.
Yeah.
And they can't dispense with that requirement of consultation prior to granting a variance. That's what Thomas says, in a regular DC zone.
That's correct.
And
yeah.
your argument is 1A of the DC allows you to sidestep the consultation requirement in the MSO for 15 because it's expressly contemplated in the DC that a variance can be granted exclusively pursuant to 11.3.
Right, it was that, exactly, that it was a very specific new variance power granted in this DC.
Okay. I follow what you're saying. I don't want to put any words in your mouth, so I just wanted to make sure I was understanding.
That's my position
Okay.
on the variance.
Okay. Okay, I have nothing further. Any more questions for Mr. Walkowicz? No?
All right.
Thank you, Mr. Walkowicz. I didn't think I'd see you again, but
Thank you.
I did. Is Mr. Gunther wanting to make any comments?
If I could, sir, just a few brief comments. I'll come forward.
Come join us.
Thank you for hearing me again. Just by way of starting, I wanted to address a comment that was made earlier in relation to the role of the city in this particular appeal. We take our direction in this matter from the Court of Appeal, particularly the direction of now Chief Justice Coular in a case that came out earlier this year called Windy Field. And the Windy Field case, it's actually 2023 Alberta Court of Appeal 1, talks a little bit about the role of the development officer and the municipality when making submissions, and confirms that it is not such that the municipality's role is simply explaining why it did what it did, but that it is available to the municipality to make submissions on, particularly in cases where reasons were not given for the development permit decision, which was the case here at the time of the issuance of the permit, for explaining its decision. And I would suggest in this case, where it is perhaps more complicated than it appears on its face, explaining solutions for the issues that have arisen at this juncture in the proceeding. So that is why we are here. That is what we are trying to achieve, and we are trying to help the board offer some solutions to what is a lot of legal concern over an 8-inch step in the front of a building. I will note that there's something unique about this particular case in relation to this either condition or variance or a universal accessibility requirement that I would suggest favors the imposition of a condition to cure the concern that has arisen, and that is that the solution to this problem, an accessibility ramp, is not something that requires a development permit. So if the applicant was going to come down to the city and seek to apply to build an accessibility ramp, they would not need a development permit because it's specifically exempted under section 12.2 sub S of the zoning bylaw as something that doesn't need a development permit. So to impose an accessibility condition, as has been suggested, it's not going to be such that there's a need for any further review because there's no development permit that is needed. That is further the case if any or all of the development is to occur on the road right-of-way, because if it's a road right-of-way development or something that is built on the sidewalk, which is part of the city right-of-way, then it needs an encroachment agreement, which isn't something that would go before the development officer, it's something that would go before the transportation department. So that's why on the unique circumstances of this case, it may be that many cases, if not most cases, are not appropriate to simply resolve something like this by way of condition. But this is a case that is unique insofar as we have a solution that specifically doesn't require a development permit, an accessibility ramp, and we have one proposed solution that doesn't require a development permit because it's on city road right-of-way. I just wanted to draw those two things to the board's attention for consideration, as the solution to this issue, I think, is most elegantly dealt with by way of a condition, a compliance condition on the development approval. Now, maybe if you have a question on that point. Okay. The other thing that I just wanted to leave the board with, and this is at risk here of going into some deep, nuanced legal interpretation, but I'm going to share it with the board for your consideration as you work through the legal issues that are at play in this matter. And that is, I don't think Thomas, in this particular case, prevents the board from granting a variance to the consultation condition. And the reason that that's the case is a very nuanced reading of what is actually before the board and what Thomas says. And the reason I say that, a starting point, is that we're dealing not with the Section 687 sub 3D variance power today. We're dealing with what is set out in the zoning bylaw, and particularly what is set out in the DC-1 in terms of the authority of the development officer to grant variances. Now, in Thomas, there's a discussion about the wording of Section 687 sub 1, and that's the basis of why the Court of Appeal held that there was no ability to grant a variance to community consultation. And that is because the wording of that variance power says that the board under Section 687 sub 3 may make an order or confirm the issuance of a development permit even though the proposed development does not comply with the land use bylaw. And what the Chief Justice said in Thomas was, well, we're looking at the words proposed development not complying with the land use bylaw, and proposed development not complying with the land use bylaw means essentially the bricks and mortar. There has to be something wrong with the development that is occurring as a condition precedent to engaging this variance power. On the other hand, if we look at what we're dealing with here, it's actually different language. And so if we look at section, I'm going back to the direct control provision, which I'm referring to that at page 60 of the appellant's submissions. It says that the development officer may exercise normal variance power, and normal variance power is not something that's defined either in the bylaw or the MGA. So interpreted on its plain meaning as a change effectively to the rules and requirements. But it also then goes on to say the development officer may exercise normal variance power for those regulations of the Main Street overlay. Interestingly, not saying may vary the requirements of the development or the proposed development, but simply a reference to the regulations. We have to continue looking to section 11 though, because it does reference section 11. And section 11 of the zoning bylaw also uses different language than we see in section 687. And it says under 11.3, the development officer may approve with or without conditions, and here's where we have some different language than the MGA, an application for development that does not comply with this bylaw. It doesn't say may approve a proposed development that doesn't comply with the land use bylaw. It actually talks about the application, so the content of the application, which suggests a more fulsome context than simply the bricks and mortar of the development. It does then go on to say that it incorporates the test, the subsequent test that the proposed development would not interfere with the amenities of the neighborhood or materially affect the use, enjoyment, or value of neighboring properties. But that's the only place we see that word proposed development, and that goes to the test itself, not what can actually be varied. So I know that is a very legally nuanced walk through the differences between the MGA and our own zoning bylaw, but I think when we follow the flow chart, and I actually over the lunch hour made a flow chart for myself to try and get my head around it, and what it led me to is the fact that there is a broader authority, and if the board feels that it needs to, in order to grant a variance to or in order to issue the development permit, if it feels that a variance is a preferable option to the condition, which I'm not sure it is, but if that's what the board determines is the case, there is a path to do that.
Anything further before I interrupt you again?
Please go ahead, that's all I have.
Any questions for Mr. Gunther? Okay, Thomas does, at paragraph 36, state that allowing the SDAB and by extension a development officer to waive community consultation would effectively render that section meaningless. So can you respond to the fact that it seems like Thomas does put the SDAB and the development officer in the same bucket in that decision, saying, well, it's not just the SDAB that can't waive this, it is also the development officer that can't waive that procedural requirement. And again, to my question that I posed to Mr. Walkowicz is, don't you still have to go through that consultation before you even get to that decision-making process? Isn't that part of the whole concept of community consultation, is to give the development authority insight into what the community thinks about this before they render a decision, rather than them render a decision without the benefit of that information?
I think the best response to that, and again, it's a path in terms of what I've explained, and it's based on the specific wording that we have in these sections. And so I think when the Chief Justice was obviously reviewing the law in the context of those sections, it was looking at those particular sections and figuring out what the implications were and what the intention of the legislator was, both at the provincial level and at the municipal level. But it could be such that it could be specifically written into the zoning bylaw that a development officer may decide to waive the community consultation requirement. And that wouldn't be offside any sort of rule or requirement. That would simply be something that could be written in and could be applied. It really depends, and there's no common law rule that there has to be consultation on a variance. It's all based on what the legislation says. So I think that's a good general rule, and I don't disagree with that comment in Thomas, but it depends on the legislation as to what the implications are. And if the legislation that we're working under is different, then it may be a different outcome. I will reinforce, though, that I think just given the uniqueness of this case, where there is perhaps a more elegant solution if the board so chooses to go down that path, that doesn't require any further development permits to be issued, that proceeding by way of a compliance condition, if that's the decision that you seek to pursue, is a much preferable option to going through the whole analysis on the variance process.
Yeah, I understand that. I think that what Ms. Agrias is going to ask this board to consider then is the option you're giving that doesn't require a further development permit is only one of the options. Mm-hmm. Some of the other options do necessitate a further development permit, including if you were to drop the sill of that door, that would be an exterior alteration. Any of the other things outside of a ramp could necessitate a further development permit. So how does a compliance condition address those possible eventualities if they were to materialize?
And if there was I suppose, a different option other than what's been put forward in the submissions that we've heard earlier today and yesterday, at that point, it may be deemed necessary to pursue that path. But at that point, it's a development permit that's solely limited to that one specific issue. What we've heard, or at least what I've heard, is that there is an option that is being proposed that involves an accessibility ramp, and that because it is something that doesn't involve a development permit, the development officer, the city, we would not need to essentially give any further approval to that unless it was, I suppose there's another option that could be an interior accessibility ramp, which would still be an accessibility ramp, which would also not need a development permit. But what we have seen here as the proposed solution would not require any further input from a development approvals perspective.
But it does appear as though this application will likely need another exterior and interior alteration permit for the changes that we've seen that aren't necessarily before us. The addition of the additional door on the east side, some of the interior alterations may or may not necessitate interior alterations. So maybe I'm not really asking a question. I'm just trying to figure out how this all falls into place. If there is a need for further exterior and interior alterations that are coming.
Yeah, and if I can't speak to any additional exterior or interior alterations that might be proposed without plans or an opportunity for the development officer to speak to those. What I can speak to just is the idea that if there is going to be an accessibility, universal accessibility is the concern. An accessibility ramp doesn't need a development permit. If that's the solution, then it's an easy solution.
And this board can't grant that ramp anyway because it would be outside of the property line. So it wouldn't be within this board's jurisdiction to even look at anything outside the property line. So
no.
I guess what I'm saying, or what I'm asking is, are you saying that if we were to condition it and a viable solution was not possible that didn't necessitate a new development permit anyway, we'd be back, well, it would be back in circulation at the city to look at those alterations that achieve either accessibility by some other means, or?
I suppose if there was something larger in scope that was being proposed than just simply an accessibility ramp, like if there was a material change that was going beyond what is excluded in the zoning bylaw or what is being proposed on the city road right-of-way, it certainly could be back before the development officer. But I don't think that what is being proposed as the solution here is something that would be back before the development officer.
Well, we've heard a couple examples. We've heard the idea of a ramp as a possible solution. We've also heard the idea of an internal ramp, which would then require lowering that door sill, right? And that would require a development permit then.
I can't speak, I'm not sure if lowering the door would require a development permit. The development officer might be able to speak to that, but if it's in the context of an accessibility ramp, I think it would depend on how structural or how significant that work was.
Okay, I have nothing further. Any more questions for Mr. Gunther? All right, thank you, Mr. Gunther, for your response to rebuttal. And Ms. Agris, we will invite you back forward for rebuttal part 2.
So I'll first respond to Mr. Walkowicz's submissions. And so regarding the universal accessibility, Mr. Walkowicz does quite rightly point out that it's not defined in the zoning bylaw. He also indicates that it can be addressed in numerous ways. True. Again, you need to see the plans to see how that is going to be addressed. Now, I'd refer you back to Mr. Johnston's submission, because this is what we originally thought we were dealing with the SDAB plans, then we thought we were dealing with the revised plans, and Mr. Johnston, in his submissions, which are part of the applicant's materials, he says, as part of the development permit, we are proposing a condition to be included which ensures compliance with the development regulations. We plan to achieve this by constructing a ramp that will provide universal accessibility to the primary entrance of the site. Barrier-free ramps or universally accessible ramps are defined in the barrier-free design guidelines. So again, that is the proposal that's on the table, is the ramp. We now have Mr. Walkowicz saying, well, actually, we can address this in any number of ways. I'd also point out that it looks like at least Mr. Johnston, on behalf of the applicant, did accept that it is the barrier-free design guidelines that do apply when you're speaking of universal acceptabilities. Now we have Mr. Walkowicz saying, well, maybe they don't, because universal accessibility can be achieved in a variety of different ways. I guess the bottom line in response to that is we don't know what the applicant's proposing. So you don't have a complete application in front of you because we don't know what the answer is or how that condition will be met, if it's going to be met. Now, Mr. Walkowicz also said, well, okay, if there is, however that condition is met, if there is another non-compliance cause, that will be an enforcement issue. Well, that's not really true, because if you approve with a wide open condition, in other words, comply with the universal accessibility requirements, then the compliance is achieved by meeting that condition. And so with that type of wide open condition, as long as universal accessibility is provided somehow, again, there's nothing to enforce. So you may create another non-compliance. Again, we don't know because we don't know what we're looking at. But there's no condition. There's nothing to enforce. So normally, again, you have a plan. The plan is stamped. And if the development is not built in accordance with the stamped plan, then you have something to enforce. Here, we're just talking about a wide open condition, comply somehow. And even if that creates another type of non-compliance, again, there's nothing there to enforce. Thirdly, and I wasn't totally sure what Mr. Walkowicz was saying, but I think I may have it. So he made a comment saying, we've got a variance power in the DC. So the DC says, refer to the MSO and then apply your normal variance power in Section 11. And then Mr. Walkowicz was saying, well, Section 819, the MSO, it also has a variance power, so you go to the DC variance power. There's no variance power in 819. What we're talking about is a mandatory notice requirement. So Section 819.4 sub 15, which is not complied with, it doesn't give any kind of a variance test. It just says if you're going to or considering a variance, here's your mandatory notice requirements. So what we're talking about is some sort of variance to the notice requirement in order to get you to Section 11. So you don't get to Section 11 without complying with the notice requirement. And based on Thomas, you can't get to Section 11, so you can't get to that variance requirement without complying with the mandatory requirements, the mandatory notice requirements in 819. Now, with respect to Mr. Gunther's comments, and I do agree with him, I looked at the building on city property, and if you need a development permit for that, and you don't. And a ramp is, I can't remember if it's called Class O, but it's in that class of development permits. If you have a ramp that's fully compliant and built within a setback, again, on your property, you don't need a development permit for that. So that's not disputed. You do need other approvals, though. And so to meet the requirements for this development, again, one of the solutions and the one that was on the table is a ramp. And so if meeting the requirements, again, if there was a proper plan or a plan like the one that's now in the materials, if that was submitted as part of the development proposal, what happens is, in the normal course, although you don't, as a standalone need for the ramp, you don't need a development permit, but in the normal course, that does get circulated. And one of the departments it gets circulated to is transportation. And presumably one of the things transportation would say, if it was circulated to them, is, oh wait, this ramp is creating a non-compliant sidewalk. It doesn't meet our standards. And I can tell you, I was down here, Mr. Haldane was here last week, or sorry, over in your offices last week, arguing about complying, transportation's requirement to comply with their standards for complete streets. And we had a whole bunch of people from the city down here, down at the board, all arguing that those requirements have to be complied with. And so again, we don't know because the circulation's never happened, but presumably if it did happen, you would have people from transportation saying, wait, you can't put the ramp there because the sidewalk is going to be too narrow now. It's not compliant. You might also have, and again, I don't know where else the circulation goes, but wherever else it goes circulated to, you might also have them look at the particular ramp that's shown on these drawings, and they might say, this ramp doesn't comply. The landing is too small. But again, we don't know because none of that's happened. And so that's why you can't have a condition at this point. This can't be dealt with on the fly, or it can't be dealt with sort of piecemeal as we go along. There needs to be a complete application. Need to see what the applicant is proposing as whatever their solution is, have it circulated, get the proper comments, and then a decision is made, and you carry on from there. Lastly, I want to talk about Mr. Gunther's comments regarding Thomas. The first thing is, and I would ask you to do a comparison between 11.3 and 687 3D. And if you put the two side by side, again, they are virtually identical. Again, there's some changes because the context is slightly different, but the wording is virtually identical. But more importantly, and Mr. Chair, you did beat me to it, but I was highlighting as the discussion was happening about whether Thomas applies to 11.3 is the wordings, what the Chief Justice says in paragraphs 36 and 37. Because essentially what she's saying is, look, it doesn't make sense to apply a variance test to a procedural community consultation requirement. You basically make it meaningless because you can always say that the variance test would be met, or you can always come up with a reason to meet it. But what she says about that at paragraph 37 is to apply a variance test to a community consultation requirement, she says such a result would be untenable, and it would be. It does seem somewhat astonishing that we have a city lawyer here, Mr. Gunther, arguing why the DO should not have to comply with a mandatory consultation requirement in a city bylaw. And again, it's one thing for Mr. Walkwich to argue that, and I would expect him to, and if I was in his shoes, I would be making similar type of arguments. But for the city to be arguing, so this bylaw represents city policy. This is the wishes of council. DO, you must consult before you grant a variance from the MSO. And now we have the city down here arguing, saying, well, here's a bunch of reasons why we don't think, and working quite hard to come up with a pretty technical legal argument. Now we don't think we should have to comply with what City Council has put in the MSO. And I would ask you, in terms of, and again, I know the Windy Field decision, I know what it says, but what about the optics? And think about, how do the appellants feel? Again, that we've got the city down here arguing why the city bylaws should not be followed, arguing actually more strenuously than the applicant's lawyer, all in trying to support a particular development. And so from the appellant's end, it certainly does make it feel like the city is not very objective. And again, it's just something for everybody to consider, is the optics, especially when you have something like this, where you have two parties, both represented by council, both entirely capable of arguing their position. And the problems associated, again, with the city entering into, again, an adversarial type of argument on the merits. So I think that's all I had in my notes in terms of responding.
Any questions for Ms. Agris? Just one from me, Ms. Agris. So if we play through this scenario where a compliance condition was imposed, there would be the need for some sort of an encroachment agreement with the city to allow a ramp to be constructed on their lands to serve the premises. Would transportation not be able to voice their concerns at that time? And should they voice their concerns and not agree to an encroachment agreement, wouldn't then the applicant be in a position where they can't satisfy that condition and would need to return to the board with some sort of a proposal for exterior alterations or a satisfactory proposal at that time?
Yeah, that's one scenario, for sure, and that might happen. Again, we don't know because we don't really know what's on the table, but that is one scenario. The other scenario is it gets approved. And I should say, it's more than just an encroachment agreement. There is a requirement, again, there's a permit required, I think, under I had the city control streets bylaw or something like that. But I'd argue actually that then, so if you're satisfying some of the permit requirements by an off-site improvement, does that not require some type of a variance? Right? Shouldn't you be able to satisfy, again, your development on your property? And so we're not talking about building something to a property line or building something in a setback. We're talking about building something beyond. And so again, I appreciate it doesn't require a development permit, but it is part of this development. And so my argument is, again, the neighbors are entitled to weigh in on this. We've got a zone with a pedestrian-friendly commercial shopping street. And so if we're going to be narrowing the sidewalk to something that doesn't comply with normal city standards, shouldn't the neighbors have a chance to weigh in on that?
Are there any similarities to when you're dealing with like a single-family home and there's a curb cut necessitated on city property that's implied in a driveway, for example? Is that? I'm just trying to think every scenario here because
a curb cut, again, a curb cut does require a permit. I'm going to suggest a curb cut isn't something that's required to satisfy the requirements of a development. So if I'm building a house, I don't need, that's not part of my structure. That's not part of what I'm building, and that's not something that's so the curb cut is not specific in the zoning bylaw. So there's nothing in the zoning bylaw that says, under whatever, I don't think RF1 exists anymore. Maybe it does in some fashion, but whatever zoning residential zoning you're talking about, there's no requirement for a curb cut in there. This is a requirement. So this is part of the requirement for the development in the zoning bylaw. And this is a structure that is being built to comply with that requirement. Whether or not it needs a development permit on a standalone basis is actually irrelevant. It's something that's needed to comply. And I'd suggest that the neighbors, if it's going beyond the property line, the neighbors should have a right, again, it should be treated like a variance. The neighbors should have a right to weigh in on that and to say, wait a second, we don't want our sidewalk narrowed to the dimension. I don't have the plans in front of me, but whatever it's being narrowed to, we don't think that's appropriate. Or we don't like what this does to the streetscape. Right? I mean, that's really one of the big points of this also is the facades. And so we're going to put a ramp in front, and maybe that isn't the solution for universal accessibility in this case. Maybe it is dropping the floor down because maybe the ramp actually isn't consistent with the look and feel of this neighborhood.
Okay, any more questions for Ms. Agrias? Thank you, Ms. Agrias. We appreciate your comments on rebuttal. And we will now go to rebuttal for Ms. Golek. So again, this is just to address comments that came to light during the presentation of the city and the respondent. Not an opportunity to introduce new evidence, or we'll be here another day.
And we don't want that. Okay, I would like to take us back to the development officer presentation. Ms. Agrios has covered a lot of it, but I would like to reiterate and review some of the points that were made. So the presentation was that the permit was received, or the application rather for permit was received. The development officer decided with the team, they made it very clear that it was a team decision, that it was a health services use. They looked at the DC1, Strathcona ARP, Main Streets overlay, and decided it's Class A permitted use, issued the permit, done. We now know that when the Main Streets overlay was applied, that the universal accessibility part was missed. The development officer also stated that she looked at previous permits and decided that health services fit in spite of the fact that the George Spady was a extended medical treatment services. So some of the information that I submitted in support of my particular appeal are the documents. There's 3 of them for Spady and 3 of them for Boyle-McCauley. And the reason was, first off, I must point out that it cost me $230 to get these darn things because I had to pay a fee. But anyway, when you look at them side by each, they are exactly the same. And that is the reason I submitted them. The same architect, the same electrical engineers, the same mechanical engineers, and in fact, the same drawing for sinks. If you look at them, particularly the background documents, they are exactly the same. And so because of this, we're looking at 2 uses approved under 2 different use categories, and therefore that should be making the application a Class B right off the rip. So then in the again undated and unsigned submission from the Development Authority to the SDAB, I'm assuming the development officer wrote it, maybe not, I'm not sure. But it's very clearly stated that it is the opinion of the development officer that the proposed Strathcona Health Hub does not unduly interfere with nor affect the use, enjoyment, and value of neighboring properties. So if, as Mr. Gunther stated, that the effects are outside of the purview for the development officer on a Class A development, why is it stated? Why were these comments submitted? I think because the use did not fit neatly into one category or the other, and there was some kind of acknowledgement that this same use was approved in 2 different ways. So there was also a comment about the mustard seed providing different services. When I was discussing density and having similar services within the same area, the mustard seed was approved as health services. You do have the building permit in your package. Again, that was another $115 to get that, but it does show that they were approved as health services, and they are offering housing supports, meals, various things that are similar to what is being proposed. Okay. Boyle Street talked about scientific studies that talk about reduced drug use around supervised consumption sites. And this is addressed in the Lethbridge study. Most of the studies that I have looked at that are talking about reduced drug use are from Seattle, they're from Vancouver, where there's huge, rampant drug users. If you've ever walked from Gastown to Chinatown in Vancouver, you see it. People are everywhere. And yes, bringing them in and helping them in that way may be seen to improve the neighborhood. In our case, in the Alberta studies, the Lethbridge study, the Sheldon Schumer, they all show quite the opposite. So again, Alberta data versus data from somewhere else. We've had city staff say more than once comments about the use versus the user. And we need to look at the use and not the user. I agree. I don't care who uses this site. The fact remains that if approved, whoever uses this site will have committed at least one crime before they get there. And following their use of this site, whoever this person may be, they are going to consume their illegal substance, and then they will emerge from the facility, and they will be in an impaired state and will roam my neighborhood. It doesn't matter who it is. The use is attracting the user who will then be in my neighborhood. This brings me to this exemption to the Controlled Drugs and Substances Act, which has been cited a number of times, this 56.1, where Mr. Mikowski said that the exemption allows this to happen as a health service or medical treatment, whatever. Anyway, this, I believe, was addressed in the provincial study, where one of the problems that arose from these sites was then some law enforcement people were seeing this as a no-go zone around these facilities, because they're saying, oh, they're exempted, so they can do it, and then it kind of escalates. Okay, the possession is okay. Well, then the sale, is that okay? And it got bigger. So there were comments about that in the Alberta study that, again, is part of your package. There was a question from the board that was, what about sending people out the door after they've consumed these substances? And the response was that, if somebody was really agitated, we would call 911 and whatever. So I'm going to refer to the Calgary Police Service report, which again is part of your package. It deals with the Sheldon Schumer facility in Calgary, which is an Alberta Health Services facility, and they have been operating the supervised consumption service within that facility. And the particular one, which is a quarterly report that is submitted as part of your package, it says, calls for service to the Sheldon M. Schumer Health Center. In the first 3 months of 2019, there were 154 publicly generated calls for service to the Sheldon Schumer Health Center. 71 calls above the 3-year average. Check on welfare, unwanted guests, assaults, suspicious persons, and disturbances were the highest volume call types, accounting for almost half of publicly generated calls. But then they go on to say approximately 2/3 of the publicly generated calls in Q1 were generated by Alberta Health Services staff or security. So this to me indicates that people aren't coming out all happy and just walking down the street. To me, it says that there were issues, at least in Calgary. Again, an Alberta city, not somewhere else. Okay. Oh, when we get to the zoning hearing that took place in January to refresh the DC1 zoning that's in place in this particular site, I was there. I made a presentation against the rezoning, and Mr. Tanti was there, and they allowed Boyle Street to make a presentation. Mayor Sohi was very clear on the fact that council was not looking at the development or potential development on the site. They were looking at the zoning. He was very clear on that fact. Okay. Yesterday it was asked if the changes to the definition of health services were proposed in the new land use bylaw. So I wasn't sure if that was answered, or I didn't hear it if it was answered. There was not a clear response. Anyway, I Googled it last night, and what do you know? From what's available online currently, oddly enough, the definitions are at the back. They're in section 810 or something instead of at the front, but anyway, it's basically the same kind of definition. So I would submit that, if the city doesn't learn anything from this appeal, they're going to be doomed to repeat history. I think that perhaps something should be done to certainly look at the definition and make some changes before the new bylaw is approved. So I would urge you to support our appeal and to deny this development, and again, to help us keep our neighborhood the vibrant historically referenced community that we know and love. Thank you.
Thank you, Ms. Golick. I'll see if there's any questions arising from your presentation. My only question is in relation, you Googled up the new zoning bylaw, and if the definition is more or less the same, and one of Ms. Agrius's comments earlier was they couldn't have even contemplated this use when the original bylaw was created because it wasn't legal at the time, does that not suggest that maybe City Council does believe health services encompasses this type of use if it's not explicitly referenced elsewhere?
Well, I think the presentation from the city staff has shown that they do think it is, and I think perhaps it has not been appealed before, and so it hasn't been thoroughly looked at.
Okay, I have nothing further for you at this time. Thank you for your comments on rebuttal. We will now hear from James Fufus. And is Jennifer on the line as well?
She is. I'm not sure if she's commenting at all.
I'll start with you and then we'll check with her.
Sure. And I prepared most of this based on yesterday's discussions. During the course of these proceedings, we have heard the City Development Authority representatives refer to health services use in its broad definition as an accepted use in the DC-1 and make specific reference to overdose prevention sites such as that proposed by Boyle Street as being therapeutic in nature. Vincent Lamb, an addictions medicine physician and medical director of Codex Medical Clinic, an addictions medicine clinic in downtown Toronto, in February 3rd, 2023 article in the Globe and Mail writes, "Injectable opioid agnostic treatment needs to be distinguished from safe injection sites or safe consumption sites where people bring their own drugs and use them while staff watch over them, ready to resuscitate them with naloxone. Note that as critical as this rescue medication is, its role is to reverse overdoses. It often puts people into terrible withdrawal and doesn't treat opioid use disorder in a continuing way. Injectable opioid agnostic treatment is not offered as a therapeutic drug addiction treatment option at the overdose prevention sites. So this reference indicates that a consumption site's primary function is not therapeutic in nature, but rather concerned with only the harm reduction component. We need to look no further than Boyle Street's own development application narrative that states, Strathcona Health Hub will provide a variety of health services, but the primary function will be an overdose prevention service. Furthermore, supervising a patron during substance use and in isolated booths and subsequently in observation rooms with the potential for administration of oxygen and or naloxone in the case of an overdose is not therapeutic in nature. It is in fact medical in nature. The U.S. Department of Health and Human Services defines naloxone as a medication approved by the Food and Drug Administration designed to rapidly reverse opioid overdose. It is an opioid antagonist, meaning that it binds to opioid receptors and can reverse and block the effects of other opioids such as heroin, morphine, and oxycodone, administered when the patient is showing signs of opioid overdose. Naloxone is a temporary treatment and its effects do not last long. Therefore, it is critical to obtain medical intervention as soon as possible after administering or receiving naloxone. These overdose events will trigger EMS emergency responses that potentially require additional medications and equipment for resuscitation and transport to a hospital for observation and admission. Sorry. The result of this immediate requirement for intervention highlights the need for appropriate setbacks and a space for EMS response that is not achievable on a busy pedestrian street with a front door access point. It is conceivable that there will be frequent instances where the attendance of police and ambulance services will need to block the corridor on the fronting street due to parking restrictions and a need for an immediate and timely response, thus substantially impacting adjacent businesses. As mentioned, prior approvals have fallen into two distinct use classes. One such instance was the Droid Spady supervised consumption site, a detoxification facility with overnight beds. When the safe injection component was applied for, independent of the prior use and separate development permit, with the sole function of providing safe injection services, this site was approved as extended medical services use. Almost simultaneously, the development officer deemed the Boyle Street safe injection site a health services use. The health services use definition does not address impacts of the security requirements and the regular needle cleanup on surrounding properties, as these characteristics are unique to this use and would not apply to any other typical use found under the broad definition of health services. By definition, extended medical treatment services is a development providing room, board, and surgical or other medical treatment for the sick, injured, infirm, including outpatient services and accessory staff residents. Typical uses include hospitals, sanatoriums, convalescent homes, isolation facilities, psychiatric hospitals, auxiliary hospitals, and detoxification centers. If you remove the words providing room and board and accessory residence, you have a use description that includes many of the auxiliary services provided by Boyle Street, including isolation facilities and a component of detoxification via the virtual opioid dependency program to connect immediately to opioid medical interventions. While the development does not have physical beds on site, staff will refer and arrange transport to patrons to locations providing room and board, which further aligns with extended medical treatment services use. And again, I refer to section 7.1 of the zoning bylaw, where specific purposes or activities do not conform to any use or definition or generally conform to the wording of two or more use definitions, the development officer may at their discretion deem that those purposes or activities conform to and are included in the use which they shall consider to be most appropriate. In such a case, the use shall be considered a discretionary use, whether or not the use is listed as a permitted use or discretionary use within the applicable zone. This bylaw does not state it may be a discretionary use, it states it shall be a discretionary use. I believe the development officer had no choice but to declare it as such. Boyle Street is seeking from this board an approval on a late submission of revised floor plans, which include significant exterior and interior alterations. It is not a matter of getting an encroachment agreement upon acceptance of the use. The changes to the plan need to be reviewed by the Development Authority and associated departments for compliance, triggering a variance, and thus would not align with a Class A development. The mere submission of late adjustments to floor plans does not absolve the Development Authority from a thorough review process and ensure compliance with DC1, MSO, and ARP guidelines, especially considering the profound impacts on the surrounding areas and businesses. In yesterday's proceedings, there were a number of mentions of jurisdiction. And upon my initial discovery of the proposed site, I too was concerned with the issue of jurisdiction regarding the development's approval. As a response to this concern, I wrote to Evan Romano, the Acting Provincial Minister of Mental Health and Addictions, and received a response on May 23, 2023. His response reads, as part of the licensing requirements, service providers must demonstrate that they have secured appropriate municipal zoning approval to offer supervised consumption services. Zoning and permitting matters are the jurisdiction of the municipal governments, and as such, I would encourage you to contact your local municipal representative. Each city in Alberta handles these matters differently, and the provision of health services at a facility does not override a city's jurisdiction. As mentioned during Murray Heinrich's presentation yesterday, that question of jurisdiction was posed to our ward councillor, Michael Jans. He had deferred back to the province as the responsible party regarding the approvals for this location, which would appear to be inaccurate, while at the same time acknowledging his shared concern for concentrations of services in this area of West Ritchie. In summary, therapeutic services would imply ongoing medical treatments of a healing nature. A supervised consumption site is not providing that type of service. What it does mainly provide is an immediate medical intervention on an outpatient basis. The Health Hub will also provide medical treatments for sick when nursing staff or doctors are available, as well as refers to beds with other services. These all fit medical service definition. Regardless, due to two different use classes being used in previous applications, the deeming rules shall apply. This is a discretionary use. And finally, the city has jurisdiction to make decisions based on where these types of services go. Based on a health services definition, these services can go nearly anywhere in the city with limited guidelines. I'd argue that the decision you have to make is a substantial one, with lasting consequences for our street and the city of Edmonton as a whole. Thank you.
Thank you, Mr. Fufus. We'll see if there's any questions arising from your presentation. Seeing none, we thank you for appearing before us in rebuttal.
Thank you.
I'll just check with Ms. Fufus. Ms. Fufus, did you have anything else you'd like to add?
No, I don't.
Okay, thank you.
Mr. Chairman, could we get a copy of that presentation emailed?
Absolutely, that was my next
Oh,
comment.
thank you.
If you could email a copy of that
Yes, I can.
statement to sdab@edmonton.ca,
Perfect.
that'd be great.
I will, thank you.
Next up, Mr. Heinrich. I have nothing to add. All right. It looks like Mr. Lau was here yesterday, but I don't think he's here today. I'll just check with admin. Don't see him on the attendee list, so we'll move on to Ms. Chen. Did you have anything you wanted to add on rebuttal?
No, I have no further comments. Thanks.
Okay. Mr. Bly? He's not here today either. Okay. Then lastly, Ms. Griesbrecht. Okay. Then I believe that's it. That'll conclude the public portion of this hearing. The board will now deliberate in camera and will render its decision in writing in 15 days' time. We thank you all for bearing with us through a two-day hearing, and we wish you all a great rest of your day.